Yesterday, my wife loves Christmas, and yesterday I noticed we had a Christmas tree in the house, and I said to her, "How long have you had this Christmas tree up?" And she said, "Oh, about 2 weeks." Yeah. So I'm sure some of you relate to that as well. You're not focusing on the holidays yet. We're back on the record on docket 24-035-04. This is the application of Rocky Mountain Power for a rate increase. It's a general rate case. And the lawyers that were here last week are here again with the exception that we have excused Captain George from she represents the federal executive agencies, multiple agencies, and she's finished with her witnesses, and so she was excused. She talked to me after the hearing last Friday, and I told her it would not be necessary for her to appear. I hope none of you will have an objection to that, because it's already been done. Before we see if you have any preliminary matters, the first item that I have is we're going to talk about the stipulation, and we have the two witnesses that are going to talk about that, Mr. Jones from Rocky Mountain Power and Mr. Dauphiné from the Utah Large Customer Group. But just let's make sure, is there anything that needs to come to our attention before we proceed with that?
I just have one schedule request.
Sure.
The current schedule has Mr. Coleman going at the end of today.
Yes.
I spoke with Ms. Schmidt on Friday and then again this morning. We would like to, if the commission is okay with that, to move him to the morning tomorrow and have potentially other DPU witnesses that don't have any cross come over in that spot. Ms. Schmidt was, I don't want to put her on the spot, she was going to check and make sure that was, what other witnesses could potentially do that. We didn't want to waste any time, of course, but also didn't want to run out of time today, and we have one scheduling issue in the afternoon, so.
Sure, I understand. And Ms. Schmidt, how do you feel about that, and what witnesses are you proposing? I know you have some that appear to me, let me make sure. You have some witnesses that have to appear tomorrow. Which witnesses would you move to today, to the 16th?
I am checking to see who is available. At this point, I believe that the best candidates are Mr. Davis and Mr. Einfeld. Each has no cross estimate next to their name.
Okay. Yeah, I don't think we have any objection to moving Mr. Coleman till tomorrow morning, and we'll take as many witnesses as we can. We'll plan on, looks like you're going to be able to arrange with Mr. Davis, Mr. Einfeld, so that may be enough.
I hope I can arrange with them. Efforts are being made as we speak.
Okay.
And they should be ready.
And we appreciate that.
Well, we'll do what we can. You know, I think that we have scheduled the 19th for a hearing, but, and I suspect we may roll over into the 19th, but I don't, on my schedule, I have no witnesses currently scheduled for the 19th, so it's possible we may be able to get done by Wednesday evening. We're pretty much back on schedule now, I think, so I think we should feel good about that. Last week I was worried we were going to go into the 20th, but but I think we're okay.
Pardon me? I have just been informed that Mr. Einfeld can go on this afternoon.
Okay.
And we are still checking with Mr. Davis.
Okay, well, we've got at least one. So let's go forward with that. We'll move Mr. Coleman until tomorrow. I suspect that'll be a longer summary as well as a longer cross, given which I read for the third time over the weekend. I will just characterize it as voluminous testimony, right? It's a lot of testimony there, which is great. Okay, so the first item we're going to consider is a stipulation between Rocky Mountain Power and the Utah Large Customer Group. It's a partial settlement stipulation. And I think let's let the parties characterize this, and then we may have some questions. As you all know, the standard here is that we need to make a finding that this findings of fact and reach conclusions of law based upon what the witness have to say to us, that this is just and reasonable in result. So hopefully we'll be able to do that today. Well, look at Mr. Saban and Ms. King, and we'll swear these witnesses and have them give the brief summary. Who would you like to go first?
We're prepared to call Mr. Jones.
And Mr. Kumar will be handling this.
Okay. Mr. Kumar, is Mr. Jones present in the hearing room?
Yes, he is.
Great. Let's have Mr. Jones come up. Mr. Jones, welcome. It's nice to have you here. If you already have raised your hand to the square without me telling you, you'll put your cup down, I guess. You raise your arm to the square. Thank you so much. You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you very much. Please be seated. We'll turn to Mr. Kumar for his questions to ask you about the stipulation.
Thank you, Chair Fenn. Mr. Jones, could you please state and spell your last name for the record?
Yep. Joshua Jones, Joshua Jones.
And what is your position with Rocky Mountain Power?
I'm the Vice President of Asset Management and Wildfire Strategy for Pacific Corp.
And have you caused to be filed rebuttal testimony in this proceeding and your associated exhibits?
I have.
And are you here supporting a settlement stipulation as well?
I am.
Chair Fenn, I'd like to mark the partial settlement stipulation as RMP Utah LCG Joint Exhibit 1.
RMP UTLCG Joint Exhibit 1.
Yes. And I have copies if we need to.
Yeah, well, you might as well pass them around. I don't know if everybody has them. Without objection, that stipulation and joint exhibit will be received.
And I'm going to go back to your testimony for a second, Mr. Jones. Do you have any changes or corrections to your testimony or rebuttal testimony?
I do not.
If I were to ask you those same questions today, would you give the same answer?
Yes, I would.
Mr. Chairman, I'd like to move for the admission of Mr. Jones's rebuttal testimony and associated exhibits, along with the stipulation that was just marked.
Okay. Without objection, we will receive the testimony, and I thought we already received this stipulation, so yeah, we're good.
Okay. Mr. Jones, have you prepared a summary in support of the stipulation?
I have.
Could you please provide that summary to the commission?
Yes. Good morning, Chair Finn, Commissioner Clark, and Commissioner Harvey. The purpose of my testimony in this proceeding is to demonstrate the continued commitment by Rocky Mountain Power to supply reliable and quality service and to support the partial settlement stipulation that the company reached with the Utah Large Customer Group, which was filed with the Commission December 10th, 2024. In their direct testimony, Utah Large Customer Group recommended the denial of $27.1 million of projects that targeted reliability improvement, and the recommended providing specific information in the company's reliability related investments in future general rate cases. In response, the company filed direct details detailing how the company's investments supported reliability and service quality, explained how the company's reliability and service quality metrics showing improving performance since 2015, and how the company's metrics compare favorably against the industry and standard IEEE benchmarks. Additionally, I described in the testimony how the company provides significant service quality reporting to the Commission on an annual basis, and this process, which was just established in 2022, provides the opportunity for customers to raise concerns regarding power quality issues to the Commission. At the request of Utah Large Customer Group, Rocky Mount Power engaged in settlement discussions between Rocky Mount Power and the Utah Large Customer Group. A settlement was reached and filed in this proceeding on December 10th, 2024. The settlement has certain components from Rocky Mount Power. The first element is an agreement for Rocky Mount Power to provide individual power quality and reliability data to Schedule 9 customers with a monthly demand above 15 megawatts. This threshold was chosen to balance the administrative efficiency of providing this information while setting a reasonable threshold for large customers with unique requirements and certain operating characteristics to receive opportunity to request this type of information. The information that will be provided is detailed in paragraph 14, subparagraph A, and subparagraph B. Subparagraph C and D detail the scope of data and the process for reviewing the data with regional business managers. Subparagraph E details the information on how customers can request high-end revenue meters, which will provide more detailed power quality information. Subparagraphs F and I detail how the company will work through these customers to resolve any issues that may be identified after reviewing their data. In response to these commitments, the company and Utah Large Customer Group agreed to withdraw their proposed adjustments of $27.1 million to plant additions associated with Utah targeted reliability improvements and Utah transmission reliability improvements. Utah Large Customer Group also agreed to withdraw some of the recommendations regarding reliability and power quality reporting in the future. While I'm not an attorney, it is my understanding the Commission may adopt a settlement if it meets the following criteria. If the Commission finds that the settlement proposal is just and reasonable in result, the evidence contained in the record supports the finding, and the settlement proposed is just and reasonable in result. When considering whether to adopt a settlement proposal, the Commission shall consider the significant and material facts related to the case. It is my testimony that the settlement meets the standard for the following reasons. The settlement is just and reasonable because Utah Large Customer Group was the only party to intervene in the reliability and power quality section, and the company has reached a settlement with Utah Large Customer Group regarding the issues in a manner that is acceptable to both parties. It does this by setting a process for requesting power quality and data and reliability data for the company, that also a process for working through these issues that are found for reviewing that data between the customer and the company. Industrial customers are unique and have different requirements from one industrial customer to another. In order to best serve the customers, the company believes, as outlined in the settlement, for the regional business managers to work with Schedule 9 customers with a monthly demand over 15 megawatts to provide individual reliability and power quality history to customers to chart the best course of action in mitigating if mitigation is required. In conclusion, I request the Commission approve the settlement as filed. Thank you.
Thank you, Mr. Jones. I think that was very helpful. Before we see what questions the commissioners have, are there any of the other parties and their counsel have questions about what Mr. Jones has just stated? Okay, let's ask questions of Mr. Jones, and if we need to, we'll call Mr. Dauphiné to the stand. He's on by video, correct? Right, he's already on. Okay. Let's turn to Commissioner Harvey to see if he has any questions.
Just one, and I noticed in the stipulation that the large customers would pay for any additional meters themselves that were required as this is implemented. That's correct, right?
That is correct for power quality monitors, yes.
Are there any other costs that kind of beyond what the normal operations would be that Rocky Mountain Power would incur to implement this?
There's a small administrative piece just to provide the reports, pull together the information, but it's pretty small and consistent with this group of customers. These customers have unique requirements, unique processes, and so it'd be for preparing that report.
All right, thank you.
Commissioner Clark.
I just have a couple of questions as well. Do you have a sense for how many Schedule 9 customers you currently serve?
Yeah, I don't have the exact number. I believe there is just over 100 Schedule 9 customers.
And a range of the kinds of requirements that they place on the system in terms of their demand? The low end is 15 megawatts, I understand, but what would be the high end?
I'm not aware. I don't have that information.
Okay. And then, do you have any sense of what the cost is of a meter that's going to provide the kinds of power quality data that some customers might require? And I'm just trying to get a sense of what kinds of costs they would bear in order to provide the monitoring that they desire.
Yeah, and maybe in clarification, there's two opportunities to provide power quality monitors. One is in a temporary capacity. The company does have power quality monitors that we utilize in a temporary capacity. Those are provided on a first-come, first-served basis. The other ones are ones that the customer would elect to procure. I don't have the exact number. They range from roughly $2,500 to upwards, depending on the type of information they would need, to about $10,000.
Yeah, thank you. And of the meters that you provide on a temporary basis, how long would those typically be in place?
Yeah, well,
I think that settlement or the stipulation might address that, but just for the transcript, if you don't mind.
Yeah, the stipulation does cover that. Let me just 60 days, and it's in subparagraph E, section 2.
Thank you, Mr. Jones.
Mr. Jones, would you help me understand subparagraph H about the process of meeting and dispute resolution and then ceasing to provide monitoring data? What's the reason that you're going to cease provide monitoring data after 1 year?
Yeah, so maybe it's to provide a little bit of context. For this class of customers, they usually are assigned a regional business manager. These customers have unique requirements, both in the way their processes they operate, their sensitivity to any sort of disturbances. And so in this section, it outlines the process for the customer to work with that regional business manager to identify any issues that they are seeing, as well as other issues that the customer may have, and identify a solution. Typically, once that information is collected based on historical experience, we usually know what the issue is between either the company or with the sensitive nature of their process, and we would identify that resolution. Additional monitoring to identify that issue would usually be resolved by identifying the solution. Once that correction has been made, and many times that is a correction or adjustment on the customer side, then we would typically engage in monitoring after that to see if that addressed the situation.
So it's anticipated that after meeting and discussing with the customer that the issues would be resolved, and there would be no need to provide the monitoring data after 1 year.
That is correct.
But I also understand there is a possibility that it can be provided if it's demonstrated that there's still a necessity for that.
That is correct. Or after resolution to confirm that resolution.
And if the designated large customer feels that they need more data, there is a provision in the stipulation to provide historical data going back 2 years, correct?
There is.
With respect to the efforts to resolve the, let's see if I can. So with respect to the projects of targeted reliability improvement and transmission reliability improvements, these are things that will be, I assume they already are ongoing in some respects, is that correct? Or?
That is correct. Yep.
Okay, and so these are projects that will be underway during the test period, but they will have an ongoing impact for years to come, I assume.
That is correct.
Okay. All right, I have no further questions. I think you can be excused, Mr. Jones.
Thank you.
Let's just hear briefly from Mr. Dauphiné as well. Thank you, Mr. Jones, very much for your testimony.
The Utah Large Customer Group calls James Dauphiné to the stand.
Mr. Dauphiné, welcome. We can see you quite clearly, and it's nice to have you with us. Where are you appearing from? Where are you located?
Good morning. It is very good to be with you. I'm participating from St. Louis, Missouri.
Okay, great. If you'll raise your right arm, we'll swear you in. Mr. Dauphiné, do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. Ms. King.
Thank you, Chair Fenn. Good morning, Mr. Dauphiné. Can you please state and spell your name for the record?
James R. Dauphiné. D-A-U-P-H-I-N-A-I-S.
And by whom are you employed and in what capacity?
I am employed by Brubaker and Associates, Inc., who are energy, economic, and regulatory consultants. I'm employed as a consultant, and I'm also a managing principal of the firm.
And have you previously testified before the Utah Public Service Commission?
I have not.
And have you previously testified before other electric service regulators, including those that regulate Rocky Mountain Power?
Yes, I've testified before the Federal Energy Regulatory Commission and over 20 different state or provincial regulatory commissions. And this has included providing testimony regarding the company before the Idaho Public Utilities Commission and the Wyoming Public Service Commission.
And are you the same James R. Dauphiné who submitted confidential direct testimony, redacted direct testimony, and exhibit JRD1 on behalf of the Utah Large Customer Group?
Yes.
And do you have any corrections to offer with respect to your testimony?
No.
And if I were to ask you the same questions as contained in your testimony, would your answers today be the same?
Yes.
And so with that, Chair Fenn, the Utah Large Customer Group would move the admission of Mr. Dauphiné's corrected direct testimony, redacted direct testimony, and JRD1 as UTLCG Exhibit 1.
Okay, without objection, the testimony and the redacted testimony exhibits are received.
Mr. Dauphiné, are you aware of and have you reviewed the partial settlement stipulation, which has just been admitted as RMP UTLCG Joint Exhibit 1, entered into between the company and the Utah Large Customer Group and filed with the Commission on December 10th, 2024?
Yes.
And have you prepared a summary of your testimony and your recommendations with respect to your support for the stipulation?
Yes.
So please proceed with that.
Good morning, Chairman Fenn, Commissioner Clark, and Commissioner Harvey. It is a pleasure to be here before you all, and I greatly appreciate the accommodation that I can do so remotely. The purpose of my summary is threefold. First, I briefly present the recommendations provided in my direct testimony. Second, I will walk through how the partial settlement stipulation, which for brevity's sake, I will refer to as the stipulation, addresses the recommendations from my direct testimony. Finally, I will detail how, from the vantage of the UTC-LCG, the stipulation is just and reasonable and should be adopted without modification. Turning to my direct testimony, the company requests approximately $27 million for various investments, which the company broadly claims will improve the reliability of its transmission and distribution system. Based on the review I performed for my testimony, I found the company's expenditures related to these types of investments have been increasing over the past 5 years, yet the company has not realized measured improvements in system-wide reliability in its Utah service territory during that same period. Furthermore, my review showed that the company provided little documentation in this proceeding, or in docket number 24-035-22, the service quality reporting docket, to support the company's reliability investments. For example, the company does not produce a distribution or transmission plan to ensure the company will maintain a safe and reliable power grid. In addition, the company's current reporting requirements do not require the company to file annual reports with voltage-specific power quality and reliability data. As a result, it is difficult to track the company's reliability performance as it pertains to a particular customer class, such as that for the company's large customers who take service under the company's rate schedule number 9. To address my findings, I made 2 recommendations to the Commission. First, I recommended the Commission deny recovery of the approximately $27 million investments identified unless the company provides evidence in this proceeding demonstrating 3 things. Those 3 things were as follows. First, how these investments will improve system reliability and reduce outage frequency and or duration. Second, that the investments' benefits outweigh their costs. And finally, that the investments are prudent. Under my second recommendation to the Commission, I recommended the Commission require the company to take steps to proactively address service quality issues and justify future infrastructure investments. Specifically, I recommended the Commission, first, require the company in future rate proceedings to provide testimony to support its reliability-related investments with data and narrative descriptions of how these investments will improve system reliability.
Jim.
Sorry, Jim. You said, specifically, I recommended the Commission first require the company in future rate proceedings to provide testimony to support its reliability-related
Reliability-related investments.
Thank you. Thank you. You can proceed.
With, yep, okay. So continuing, reliability-related investments with data and narrative descriptions of how these investments will improve system reliability. Second, require the company in future rate proceedings to provide reliability metric and power quality data by specific customer classes and or voltage levels. And finally, before the next rate case, require the company to establish a formal process for large customers to report and resolve issues related to power quality and service reliability with the company. This would involve improved access to customer data, coordination with customers' existing account manager, and, if necessary, a formal reliability complaint process to identify feasible solutions and ensure satisfactory resolution to address the identified power quality or service reliability issue, particularly when the issue is chronic, high impact, or high risk. Subsequent to the filing of my direct testimony, the company filed rebuttal testimony from Mr. Joshua Jones, who you've heard from today. And the company and UTLCG exchanged communications regarding resolution of the issues raised in my direct testimony. Those culminated in the partial settlement stipulation in this proceeding that was filed on December 10, 2024. Under the stipulation, the UTLCG agreed to withdraw my recommendations in exchange for the company agreeing to provide individual reliability and power quality data upon request to any Schedule 9 customer with over a 15 megawatt monthly peak demand. These designated large customers will contact their assigned regional business manager within 30 days of the final order approving the stipulation in order to obtain their individual data from the company. A lengthy list of what individual data can be requested by each designated large customer from the company is detailed in the stipulation and provides several different options for each designated large customer. It also entitles the designated large customer to request specific review of its reliability and power quality data, or both, and requires the company to comply with the request in a timely fashion. The company is required to provide the requested data on a quarterly basis for a period of 1 year after the final order in this proceeding. In addition, the company is required to meet with each designated large customer to discuss any chronic, high-impact, or high-risk issues, and is required to continue to provide monitoring data after the required year if the designated large customer can demonstrate value in receiving additional monitoring. Finally, the stipulation requires the company and the designated large customer to work cooperatively to resolve any identified chronic, high-impact, or high-risk issues. The stipulation is just and reasonable. Let me restart. The stipulation is a just and reasonable resolution of the issues it addresses. This is so because it directly addresses the concerns that underlie my testimony. Specifically, UTLCG's concerns with respect to whether the company's investments are measurably improving or at least reasonably sustaining the reliability and power quality required by the company's large industrial customers in Utah. As detailed in my direct testimony, these customers require consistent power quality and uninterrupted electricity to ensure safety, maintain efficient operations, minimize financial and production losses, ensure product quality, and to mitigate potential environmental impacts. Without a doubt, reliability is important for all the company's customers. And so, without intending to minimize the impacts of poor reliability on other customers, I want to describe the unique challenges faced by large industrial customers, such as those who take service under Schedule 9, when the electric power service they receive from the company is not reliable or of insufficient quality. Sudden outages or variations in power quality can create hazardous situations for industrial employees, increasing the risk of accidents or injuries. In addition, industrial safety features might not function properly without power. Downtime due to power outages can significantly impact production schedules and lead to massive financial and production losses. Even momentary outages or variations in power quality can result in long-term interruptions to production while industrial manufacturing equipment is brought back online. Critical industrial processes often rely on computer systems and automation. Power disruptions can lead to data loss, system malfunctions, and security vulnerabilities. Also, oftentimes, quality control issues can occur because of production interruptions. In industries like chemical manufacturing, temperature control processes can be disrupted, leading to potential safety hazards with hazardous materials. Industrial facilities often have systems to monitor and manage air, water, and waste. Power outages can disrupt these controls, posing environmental risks like the release of harmful pollutants, leading to potential environmental damage and liability issues. In addition, power quality and reliability issues can have major impacts in a competitive market, resulting not only in the loss of production, but also dissatisfied or lost customers. Notably, this has impacts far beyond the particularly affected industrial customer and affects Utah's ability to attract and retain businesses for the benefit of Utah's economy. While these large customers can and do make significant investments in protective electronics such as breakers and relays to help mitigate potential issues, there are limits to the level of protection that customer-side power protection devices can provide. Industrial customers may still experience further financial losses either from replacing protective equipment or ancillary damage that occurs during more extreme outages and power quality events. RMP does not currently disaggregate the reporting reliability metrics between service voltages and customer classes. As a result, all reliability metrics are reported on a system-wide basis. As a result, RMP's reliability metrics essentially assume all outages are experienced equally. The stipulation addresses all of these issues by committing the company to provide individual data to designated large customers and to work with those individual designated large customers to identify and resolve the reliability and power quality issues that are adversely affecting them in a timely fashion. The stipulation also places a heightened importance on the communications between the company and designated large customers to address chronic, high-impact, or high-risk issues. This process has the potential to avoid the need for customer complaints or any issues with access to a designated large customer's data. For these reasons, the partial settlement stipulation is just and reasonable and should be approved by the Commission. Thank you. This concludes my oral testimony. I welcome any questions you may have.
Thank you, Mr. Dauphiné. Before we go to the commissioners, any parties have any questions or clarifications? Okay, let's go to Commissioner Harvey.
Good morning.
Good morning.
It's clear from the testimony in this case and in other dockets and from the stipulation that the large industrial customers that are the subject of this stipulation need a level of quality that is considerably beyond what a typical residential customer might need. Is that correct?
Yes, but within the standards that apply to providing power quality and reliability.
To the extent that the resolutions that are anticipated of coming out of this stipulation for specific problems end up costing a fair bit of money at the margin, do you have an opinion as to what would be a reasonable allocation of those costs?
No, I would go turn to the company's standard practices on how they address those situations today, because they do come up from time to time. This is not a new phenomenon. So I would defer to the company's current practices on that and Mr. Jones, for example, might be able to better address that.
Thank you, that's all I have.
Commissioner Clark?
I don't have any questions. Thank you, Mr. Dauphiné.
I don't have any questions either. Let us take a 5-minute recess as a commission, and we'll be back. You're excused, Mr. Dauphiné, unless you want to stay on until we make a ruling in the next 5 minutes.
No, I appreciate it. Thank you.
Thank you so much for your testimony, and we hope you have a wonderful holiday season.
I wish you
You're
all the same.
excused.
Thank you.
Back on the record. So we've had a brief recess. Here's how we're going to rule on this partial settlement stipulation. The stipulation was reached between Rocky Mountain Power and the Utah Large Customer Group. It's our understanding pursuant to the second paragraph of the stipulation that none of the other parties, interveners in this docket, have any opposition to the stipulation. The stipulation deals with the resolution of reliability and power quality issues. Those are set forth. The specific terms of those agreements are set forth in paragraphs 13 with subparagraphs through 17. We make a finding of fact and our conclusions of law with respect to those. Those are appear to be agreed at arm's length between the parties, that they provide for individual reliability and power quality data upon request as any Schedule 9 customer. We think that that's reasonable and is just and reasonable in result. With respect to the other general terms and conditions of the stipulation, we also make a finding that those are just and reasonable in result. And based on the evidence received by the summaries of both Mr. Jones from Rocky Mountain Power and Mr. Dauphiné from the Utah Large Customer Group, we conclude that the stipulation is in the public interest, that it's just and reasonable in result, and the findings and facts that we make today and conclusions of law will be set forth as a and with some fleshing it out further, will be set forth in our final order, in this case addressing all sorts of other issues, but we'll have a section with respect to this stipulation. That order will be issued on or before April 25th, 2025. It may be that there will be other questions we have with respect to this stipulation in phase 2 when we're talking about cost of service and rate design, and we'll address those at that point in time. Okay, so that's those are our findings, and we consider this matter resolved. Any questions or any clarifications? Ms. King.
Thank you, Chair Fenn, and we appreciate the ruling. In response to your final statement, where some of these issues with respect to cost of service and rate design might arise in phase 2, we wanted to just clarify, would you like for us to have Mr. Dauphiné be available in phase 2 where he otherwise wouldn't have been? And no need to tell us today, but if ahead of time we could know that, that would be helpful.
I don't know the answer to that right now. I think we want to further consider that, but we will certainly give you plenty of notice. But we'd be happy to accommodate the same arrangement of an appearance like we had today.
Much appreciated. Thank you.
Okay. Any other questions? Any other concerns? Okay. We will then proceed with the next witness in this matter, which I believe would be Mr. Mitchell. And Ms. Hayes, you're going to...
Yes, I will be doing the direct examination of Dr. Mitchell on behalf of Utah Clean Energy.
Yes, I should have... I did know that you were Dr. Mitchell, so I apologize for calling you Mr. Mitchell. I think Dr. Harvey would appreciate being called Mr. Harvey, so anyway, I'm just teasing. Dr. Mitchell, will you raise your right arm? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. You may be seated. Ms. Hayes, thank you for taking this on.
My pleasure. Thank you. Good morning, Dr. Mitchell. Will you please state your name and title for the record when you're ready? Didn't mean to rush you.
My name is Dr. Logan Mitchell, and I'm a climate scientist and energy analyst for Utah Clean Energy. My name is spelled Logan Mitchell.
Dr. Mitchell, did you submit direct testimony and surrebuttal testimony on behalf of Utah Clean Energy in Phase 1 of this rate case?
Yes, I did.
Do you have any corrections to any of your pre-filed testimony?
No, I do not.
If I asked you the same questions today as set out in your pre-filed testimony, would your answers be the same?
Yes, they would.
With that, Utah Clean Energy will move to admit Dr. Mitchell's direct and surrebuttal testimony.
Without objection, they are admitted.
Dr. Mitchell, have you prepared a summary of your testimony for the commission today?
Yes, I have.
Please proceed.
Good morning, Chair Fenn and Commissioners Clark and Harvey. Thank you for the opportunity to provide testimony today. Since my background is a little different than most of the folks here, let me address that first briefly. I got my PhD from Oregon State University studying paleoclimatology, measuring greenhouse gases in ice cores, and studying glacial and interglacial climate changes. I've been to Antarctica twice drilling ice cores, and then after my PhD, I completed a twice measuring, drilling ice cores. Yes. Yes, sure. And then after my PhD, I completed a postdoctoral fellowship and was later a professor at the University of Utah, studying how emissions from energy systems in urban centers affect atmospheric chemistry and air pollution. I've also published on Utah's air quality and energy history, which is a fascinating story of Utah's long legacy of balancing environmental stewardship and economic development to reduce emissions and improve quality of life. For the last almost 3 years, I've worked at Utah Clean Energy, leading our utility regulatory team, and have been extensively involved in Pacific Core dockets and stakeholder processes. So my testimony draws on my background as a climate scientist and provides a brief overview of climate science, from what's causing climate change to what the impacts are projected to be, and how these costs and risks directly affect ratepayers and the company. It's clear that climate impacts are not exogenous to the company's operations, and indeed the entire electricity sector has a significant role to play in mitigating future climate impacts. For context, the electricity sector in Utah is responsible for about 48% of Utah's total energy-related greenhouse gas emissions, and Rocky Mountain Power serves around 85% of households in Utah. So the company is responsible for a significant share of Utah's greenhouse gas emissions. My testimony shows that the costs and risks posed by climate change need to be managed, and the company should be appropriately incentivized to do so. So I'd like to start by briefly talking about climate science, and especially how it relates to the electric utility sector. First, greenhouse gas emissions from human activities, including power generation, have changed the climate system, and will continue to do so while we continue to produce more emissions. The best estimate of how much human activities have affected the climate system is that essentially all of the climate warming we're observing today is driven by human emissions. There is a near linear relationship between emissions and overall climate warming. So every ton emitted contributes to additional warming, and the overall level of warming is a function of our cumulative carbon emissions. That is why climate change is not exogenous to the company's activities. The emissions from our monopoly electric utility company contribute to climate change. While there's a linear relationship between emissions and overall warming, the relationship to societal impacts, costs, and risks is not linear. This is represented qualitatively as the reasons for concern framework presented in my direct testimony. As the scientific community has examined these climate-induced risks over the past 2 decades, we've come to understand that severe climate impacts will occur at lower levels of climate warming. These impacts are now becoming apparent at about 1.1 degrees Celsius of warming, which is the average over the last decade. And continued warming will cause increasingly severe societal costs and risks, which of course includes costs and risks to ratepayers. One of the main takeaways from my testimony is that the climate impacts we're seeing today will pale in comparison to the massive scale of systemic societal impacts projected if there is significant future warming. In this case, every 1/10 of a degree matters and increases the costs and risks of climate impacts. Now, I want to be clear that it's not just wildfires that are imposing costs that we're seeing in this rate case. Heat waves are driving up demand and peak power prices. For example, the extreme heat wave that we discussed in the Pacific Northwest. Extreme temperatures can also derate thermal plants. Drought can limit low-cost hydro generation. Extreme weather events, like some winter storms that are associated with shifting climate patterns, can affect other kinds of infrastructure like natural gas storage facilities. And of course, there's the increasing severity and extent of wildfires. For wildfire risks in particular, I highlighted several recent studies in my testimony that explain that each added increment of warming increases the frequency and severity of wildfires. And if we as a society can reduce emissions and hold warming to less than 2 degrees Celsius, if we as a society can reduce emissions and hold warming to lower than 2 degrees Celsius, wildfire conditions should stay within historical ranges. However, with greater warming, we'll see vastly increased wildfire severity and extent. As has been noted in this hearing, wildfires pose one of the most significant business, operational, and financial threats to the utility business, and therefore have a detrimental impact on ratepayers. It's therefore in the economic interests of the company and ratepayers to limit future warming. So what is the utility sector's role in reducing emission? There's broad consensus that keeping warming below 2 degrees Celsius would mitigate the severity of climate impacts. With that target in mind, a recent study of coupled energy economy models found that the U.S. would need to reduce its economy-wide emissions by around 50% by 2030. Since the utility sector has cost-effective and near-term emission reduction opportunities, the emission reduction target for the electricity sector is 80% by 2030. PacifiCorp's 2023 IRP least cost, least risk portfolio contained a substantial build-out of clean energy and storage resources that attained a 78% reduction by 2030, which in my view was basically aligned with the electricity sector emission reduction target. However, shortly after the 2023 IRP was issued, the James verdict came out, and in our view, everything changed. Climate impacts had caught up with the company in a material way, as they've caught many other utilities across the country. Then the company canceled the 2022 all-source RFP and issued the 2023 IRP update that charted a dramatically different path for the company's future by substantially scaling back the amount of storage and solar that they were planning to build, delaying wind resources, and compensating for that with a large increase in coal generation. The combined effect is that PacifiCorp's emissions would no longer be aligned with the electricity sector emission reductions and would have 114 million metric tons of cumulative carbon emissions more than the 2023 RP, which is an increase of about 39%. It's ironic that climate-fueled wildfire costs and impacts have derailed PacifiCorp's progress in reducing their emissions that are contributing to climate change in the first place. The challenge we're facing is that if the company is allowed to shift the costs and risks of climate impacts onto ratepayers, that will create a moral hazard situation, which has already come up before in this hearing. In this situation, the moral hazard is that the company would have no incentive to do their part to reduce emissions and reduce climate impacts if ratepayers can be expected to bear the costs and risks of climate impacts. Company witness Joel Stewart's rebuttal testimony mentioned that the company must balance their energy transition with maintaining reliability, rate impacts, and the company's financial stability. I addressed these concerns in my rebuttal testimony and explained that, in my opinion, each of these concerns actually support more clean energy development, not a delay. The company's own IRP shows that the grid can accommodate and operate reliably with a substantial increase in renewables. And research is now emerging that is finding that renewables can actually increase reliability of the bulk power system in the face of extreme weather events. As far as mitigating rate impacts, in this rate case, a substantial portion of the increase in costs is from fuel costs and climate impacts. Fuel-free resources limit exposure to fuel price volatility while also reducing emissions. It is, however, important to have a steady build-out of resources because it would be far more costly to have an extensive build-out of resources in a short period of time. And those kinds of plans would be susceptible to external factors like supply chain constraints or inflation or other disruptions. So a steady build-out of resources is important. And that's why we're concerned about the cancellation of the 2022 all-source RFP. Lastly, if wildfire risks pose an existential threat to utilities, then certainly reducing emissions is one of the many pieces of the puzzle needed to support the financial stability of the company. As a monopoly utility, the company has the primary control over their own emissions and a responsibility to mitigate risk to ratepayers. In their most recent 2023 IRP update, the company has walked back their emission reductions, and in this rate case, they're asking ratepayers to shoulder climate and wildfire costs and risks. Company witness Stewart recommended in her rebuttal that the commission take no action based on my testimony. However, these are material costs and risks, and it does not make sense to take no action to manage them. Therefore, my recommendation is that this commission evaluate the distribution of climate-induced costs and risks, and in particular wildfire risk, between ratepayers and the company. Further, I recommend the commission explore options that would ensure the company is incentivized to mitigate its contribution to climate risk facing its system by tying cost recovery mechanisms for wildfire and other climate-fueled risks and clean energy build-out to cost-effective emission reductions. Thank you. This concludes my summary.
Thank you very much, Dr. Mitchell. Ms. Hayes?
Dr. Mitchell is available for questions.
Okay, Mr. Saban,
No questions from Rocky Mountain Power.
any questions from anybody else? Okay, let's go to Commissioner Harvey.
Just a couple of clarifications. When you were talking about the original 2023 IRP, you said that it would almost meet those targeted emissions, I think was 78 versus 80%. And you mentioned a change with the update, comparing it to the 2023, but how close would the update get to the target?
I believe it was 63% by 2030.
63-ish, okay. All right. Let's see. So as you mentioned, any ton of carbon or any other carbon equivalent greenhouse gas would essentially have the same long-term effect no matter where in the world it's produced?
For carbon dioxide,
Yeah,
that
I'm
is,
sorry, carbon
that is
dioxide.
true. For other gases, there's different lifetimes in the atmosphere and different chemistry involved, but for carbon dioxide, that is the case.
Right, right. So for a given type of gas, the long-term effects would be different, but the effects would be the same regardless of where it's produced, right?
That's correct.
All right. So Pacificor's emissions of greenhouse gases are a relatively small percent of the worldwide total, correct?
That's correct.
So how, I mean, I guess what I'm trying to find out is would it make a significant difference if Pacificor met a target but nobody else did?
So that's a really good question. And it's true that no one utility or entity by itself can solve climate change. It's a collective problem that needs to be addressed collectively. One of the challenges for this particular situation is that we have a company has a monopoly over a certain service territory. So it's not like you can just switch to another, you don't have another option to go to. In a free market, you might be able to choose a different company that might have a different emissions pathway. So I think that changes the calculus for the duty of the company to serve the long-term public interest. And as I mentioned, it's a collective problem, and so every entity needs to do their part. And while they're a small percentage of the global emissions, it's an important contributor from Utah.
This isn't directly related, and so if it's beyond what you're capable of answering, just say so. But I know that many Utah customers, both at the residential level and larger customers, have invested in private renewable resources. How large of a effect has that had?
I don't have that information at the tip of my fingers.
Okay. All right, thank you. That's all I have.
Commissioner Clark.
I don't have any further questions. Thanks, Dr. Mitchell.
Dr. Mitchell, I have a couple of questions. So I believe you testified that once CO2 is emitted from a source, that it remains, what happens? How long does that remain in the atmosphere?
So it's a good question with a complicated answer.
Go ahead, give me your best shot.
I'll give you the very brief summary is that there's 3 main processes by which CO2 is removed from the atmosphere. There's interactions with the biosphere, so plants take up CO2. That's one mechanism that operates pretty quickly over the spans of tens of years. But then there's also a collaboration with the ocean, and then ultimately a lot of the carbon gets exported and things in the ocean die and sink to the bottom of the ocean, and it gets reincorporated back into rock. So the time scale in each of those different processes have different time scales associated with them. So that's why it's complicated, because there's multiple processes with multiple different time scales. But some of the CO2 that's emitted today will be in the atmosphere for tens of thousands of years.
So my understanding is the Paris Agreement that was entered into by 195 countries some years ago set goals to reduce CO2 emissions by the year 2030. Is that correct?
That agreement was focused on a level of warming.
The 2 degrees Celsius warming, or 1.5%.
Yeah.
But in the United States, there's been a lot of discussion among emitters about reducing CO2 emissions and having standards to do so by the year 2030, correct?
Yeah, that's one of the targets that countries are aiming at, because it's near term and focused on policy mitigation in order to meet those targets.
So what's the rate or the pace of climate warming, and it may be accelerating? How many years before you anticipate, in your professional opinion as a scientist, that the Earth temperature will rise 1.5 degrees centigrade?
So in terms of a climatological definition, canonically we usually look at a 30-year window in order to say we've crossed any certain temperature threshold. And so it may be a number of years before we can say definitively, climatologically, that we've crossed 1.5 degrees Celsius. We will probably exceed that temperature level on an individual year basis this year. But then, because you're averaging over 30 years, it might take another 15 years before we've officially crossed it.
And what level of warming, in your testimony you talked about some catastrophic impacts and even existential threats to our planet. What level of climate warming do you opine is necessary or would be the level at which you would see such catastrophic effects? How many degrees Celsius?
In the reasons for concern, they have this bar chart. It's called the burning embers diagram, and that kind of qualitatively provides the best synthesis that we have. And what that shows is that going between 1.5 and 2 degrees Celsius, we cross the high risk into the high risk territory for several of those reasons of concern. And those, there are several different topic areas, and we're already starting to see massive impacts on sensitive ecosystems like coral reefs. I think this year it was something like 77% of the Earth's coral reefs had a heat stress bleaching, coral bleaching event, which is just an astounding amount of impact on those ecosystems. And there's something like 1 billion people in the world that get their primary source of protein from these coral reef ecosystems. So that is a major societal impact. The Arctic is undergoing massive and rapid ecological changes right now. And what happens in the Arctic doesn't stay in the Arctic, it affects everything. And we're also potentially facing climate tipping points, such as I know a lot about the fate of glaciers in Antarctica because I was there drilling and very familiar with glaciology down there, but also ocean currents that could be fundamentally entering different, could get reorganized, and that would affect climate patterns and storm track patterns globally. And that's not to mention all of the heat waves and severe climate impacts and droughts and extreme precipitation events that we're already seeing. And we'll only get worse.
Okay, thank you. Turning to your testimony on page 18 of your direct, in lines 255 through 259, you state in the original 2023 IRP that Pacific Corp would emit a cumulative 293 million metric tons of CO2 between 2023 and 2050. Is that correct?
That's correct.
And then in the 2023 update, you state that the projected cumulative CO2 emissions would increase by 407 million metric tons. And that's where, in I think your summary, you gave a delta. Is that right? The delta was what was it again? I haven't added it up.
It's 114.
114 more million metric tons of CO2 over a period of 27 years.
That's correct.
Now, how often does Pacific Corp come out with an IRP?
Every 2 years.
So that can change if they change their resource mix. Is that correct?
That's correct.
As I take it from listening to you and reading, I've read your testimony a couple of times. Tell me if I'm wrong in this conclusion. You're not saying that Pacific Corp isn't taking action to reduce CO2 emissions. I take it your concern is they're not doing enough.
That's correct.
Because in fact, the updated IRP projects a 63% reduction in CO2 emissions by 2030. Is that correct?
That's correct.
Okay. But in the meantime, you're concerned about the increase in cumulative carbon emissions.
That's correct.
Now, I want to turn to one of the things that you said about how do you think the commission could incentivize Pacific Corp to do more? Your issue is that there should be that all of the costs, this is where you talk about moral hazard, that all of the costs of the wildfire costs and other costs associated that have a climate emission component should not be borne by ratepayers. That there should be some allocation, if you will, to incentivize the company by putting some of that cost upon shareholders. Is that your testimony?
Yeah.
How would you do that? What is your, what's the details of your proposal, if you've given that some thought? How would you incentivize, and what would you recommend?
That is a really challenging question, which is why we didn't have very specific recommendations. And I think that, I think it would probably not make sense to impose draconian measures upon the company kind of out of the blue. And so,
why would that be?
Because it would be difficult. I think it would be challenging for the company to adapt to that on a short period of time. And our view is also, we are prioritizing, affordable, reliable, and clean electricity mix. And our view is that having a financially solvent company is important for reliable and affordable electricity. So I think that this is more of a conversation that will happen over time rather than immediately. And so we wanted to introduce this testimony here because the issues of climate risks have come up in this rate case. And so we think that we can begin having that conversation here and have it progress through future proceedings over the coming years so that the company has time to adapt and understand what the commission, I guess it's the principle of gradualism, which we would support. As a specific example of what things could be done, or the ways that this could enter into the calculus that you all do in making a final decision, on Friday, Mr. Higgins was talking about disallowance associated with the Gateway South project. And I don't want to either agree or disagree with their method of calculation. I'm not sure that I know or have an opinion on which is the right way to do that. But he was arguing that there should be a 39% disallowance for that facility. But then mentioned that reliability concerns might reduce that disallowance because reliability concerns, it's a more qualitative assessment of how that facility might affect the overall operation of the grid. We feel that climate concerns might also weigh into that kind of a calculation that is enabling more zero fuel cost and low carbon generation under the system. It provides generation diversity, and so that may be another thing that could weigh in. Like if the decision was that some of those costs weren't prudent, but you wanted to reduce that disallowance, that might be where that kind of a conversation or that kind of a calculation might weigh in. That's one example. Certainly in phase 3, initially when I wrote the testimony, there was no phase 3, and we kind of were thinking that this testimony would apply to those other dockets. Now there's a phase 3, and I think we'll revisit some of these arguments in phase 3.
Sure, you'd be welcome to do so. Let me just ask the question. You understand, obviously, that a company could be constrained by the amount of capital that they have or are able to raise. To bring online clean energy generating resources, is that correct?
I think that conceptually makes sense to me. There's been a lot of discussion within the hearing about whether or not that's the case and at what level they might be constrained.
Sure.
But conceptually, that, yes, makes sense to me.
And my understanding is that under the current modified or revised IRP, that the company intends to operate its coal-fired generating units for the balance of their economic lives. It's that 2038 or 2042, is that correct? Do you know?
That is the current plan. That is the current planned retirement dates. And, we will see how the economics change. There's been some changes in coal prices that have been discussed, that are discussed in this rate case. And, economics are changing rapidly, especially with batteries and clean energy also. So economics of all of the generation resources are changing all the time, which is why they update IRP every 2 years. But yes, currently the planned retirement dates are 2038 and 2042, although the planned utilization will be declining before that.
Great, thank you for that. As an expert in this field, are there coal-fired generation plants being built or on the drawing board anywhere in the world right now?
Yeah, there are certainly some that are being built in China and in a few other places.
Right.
But not many, and that's changing quickly.
And in your professional opinion, do you believe that there are, at least as the climate of political and economic climate that exists in the United States now, do you foresee other coal-fired generation plants being built in the United States?
In the United States, no.
Okay, I have no further questions. Thank you very much, Dr. Mitchell. Appreciate it.
Thank you.
We'll excuse you. And it sounds like we may see you in phase 3.
Quite possibly.
Okay, all right, thank you. Okay, as I understand it, it looks like Mr. Garrett will be the next witness. Is that correct?
That's
Okay.
correct.
Ms. King, we'll turn to you then.
Wonderful, thank you. The Utah Large Customer Group would call David Garrett to the stand.
Mr. Garrett, welcome. Will you raise your right arm? Do you solemnly swear that the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. You may be seated.
Thank you.
We'll turn to Ms. King.
Good morning, Mr. Garrett.
Good morning.
Would you please state and spell your name for the record?
My name is David Garrett, D-A-V-I-D-G-A-R-R-E-T-T.
And by whom are you employed and in what capacity?
I'm the managing member of Resolve Utility Consulting.
And are you the same David J. Garrett who submitted direct testimony and exhibits DJG 1 through DJG 16, along with Appendix A and B, on behalf of the Utah Large Customer Group?
Yes.
And do you have any corrections to offer with respect to your direct testimony or exhibits?
No.
And are you also the same David J. Garrett who submitted surrebuttal testimony on behalf of the UTLCG?
Yes.
And do you have any corrections to offer to your surrebuttal testimony?
No.
And if I were to ask you the questions contained in your testimonies today, would your answers be the same?
Yes, they would.
And with that, I would move the admission of Mr. Garrett's direct testimony, exhibits, and appendices collectively as UTLCG Exhibit 2, and Mr. Garrett's surrebuttal testimony as UTLCG Exhibit 3.
Thank you for that. I won't attempt to repeat exactly what we're admitting, but you all got that. And Without objection, I see none. We will admit the testimony and exhibits. Thank you.
Thank you. And Mr. Garrett, have you prepared a summary of your testimony?
Yes, I have.
Please proceed with that.
Just a moment, Mr. Garrett. This is my plan. Well, let me ask the question. Mr. Saban, how much cross do you anticipate of Mr. Garrett? Some.
I think it will be less than what we previously anticipated, but we wanted to hear what he had to say.
I'm just trying to figure out, we'll want to take a break this morning. What I would propose, if this doesn't make you uncomfortable or mess up your schedule, is let Mr. Garrett give his summary and then take a break. Is that
Perfectly
acceptable
fine.
to you?
Acceptable, yes.
Okay, all right, thank you. I apologize for interrupting you, Mr. Garrett, but we're ready for your summary now.
Okay, thank you. Good morning, Chair Finn, Commissioner Clark, and Commissioner Harvey. My name is David Garrett, and I'm testifying on behalf of the Utah Large Customer Group. My testimony in this case addressed the cost of capital, capital structure, and fair rate of return for Rocky Mountain Power in response to the direct testimony of company witnesses Ann Bulkley and Nikki Koblia. In this case, the company is requesting an authorized return on equity of 9.65%. In addition, the company proposes a hypothetical rate-making capital structure consisting of 50% debt and 50% equity. Based on my review, the company's proposed rate of return significantly exceeds any reasonable estimate of its cost of capital. The authorized rate of return in this proceeding should accurately reflect a reasonable estimate of the company's market-based cost of capital, which can be closely estimated through the use of financial models such as the discounted cash flow model, or DCF model, and the capital asset pricing model, or CAPM. Thus, the authorized rate of return should not be based on an average of authorized ROEs from other jurisdictions that occurred in the past. Doing so would likely result in an authorized ROE for the company that clearly exceeds any reasonable estimate of its cost of equity. When the authorized ROE exceeds a utility's cost of equity, it results in an excessive and unfair transfer of wealth from customers to shareholders. If the Commission sets an authorized ROE that closely reflects a reasonable estimate of the company's cost of equity, it will afford the company an opportunity to earn a fair rate of return for its shareholders and to remain financially healthy. I conducted 2 variations of both the CAPM and DCF model. The results of my analyses indicate a range for the company's cost of equity from 7.6% to 8.8%. I recommend an awarded ROE of 8.8% for RMP, which is the top end of my cost of equity modeling range. Ms. Bulkley conducted several variations of the DCF model, which produced results ranging from 9.4% to 11.65%. The results of Ms. Bulkley's DCF model are overstated primarily because of her reliance on non-sustainable growth rate assumptions. Ms. Bulkley used long-term growth rates in her proxy group as high as 12.5%. This growth rate is more than 3 times the rate of projected U.S. GDP growth. Even the average growth rates assumed for her proxy group are above 6%, which is nearly 2 times projected long-term GDP growth. Ms. Bulkley's growth rate assumptions violate the basic principle that no company can grow in perpetuity at a greater rate than the economy in which it operates. This is especially so when dealing with a regulated utility company with a defined service territory. The results of Ms. Bulkley's CAPM range from 10.5% to 11.92%. The primary problem with Ms. Bulkley's CAPM results stems from her equity risk premium, or ERP, estimate. Ms. Bulkley used an input as high as 8.21% for the ERP. This estimate is not reasonable. The ERP is a key input to the CAPM equation, and it is one of the single most important factors for estimating the cost of equity in this case. I used 3 widely accepted methods for estimating the ERP, including consulting expert surveys, calculating an implied ERP based on aggregate market data, and considering the ERPs published by reputable analysts. The average ERP calculated from my sources is only 5%. This means Ms. Bulkley's ERP is significantly higher than the ERP estimate reported by thousands of expert survey respondents and other objective sources. I would also like to speak on the company's narrative that the commission should provide regulatory support, in this case by adopting RMP's proposed rate of return. Specifically, Ms. Bulkley stated the commission should consider RMP's wildfire risk when setting the company's return on equity to reflect what she believes is heightened investment risk in Pacificorp. Although Pacificorp presents this as a risk affecting the industry overall, it is primarily a firm-specific or company-specific risk the company has essentially created in connection with its grossly negligent, reckless, and willful behavior in causing the 2020 Labor Day fires in Oregon. The fact that RMP has attempted to use company-specific risk factors to bolster its ROE is not a unique strategy. I've testified in dozens of cases around the country, and I cannot recall a single case in which the utility's ROE witness did not attempt to list a number of company-specific risk factors, whether hurricanes in Florida or tornadoes in Oklahoma, that they suggest should have an increasing effect on their client's awarded ROE. I have never seen it move in the other direction, however, where a utility suggests their company-specific risk factors are somehow less than the proxy groups and should thus have a decreasing effect on the cost of equity. The bottom line is that these risks are already reflected in utility stock prices and analyst projections, such that the results of the DCF and CAPM models should not be increased for out-of-model company-specific risks. Further, it is a common understanding in finance and investing that the market does not reward firm-specific risks, such as Pacificorp's wildfire risk. Rational investors diversify and minimize such risks by investing in multiple companies, multiple industries, and different types of investments. Next, regarding capital structure, the Commission should reject the company's proposal to use a hypothetical capital structure which favors high-cost equity instead of low-cost debt. The company's proposed hypothetical capital structure consists of much lower debt than its actual projected capital structure and much lower debt than the average capital structure of the proxy group. Here it is important to note that even though Ms. Bulkley and I use the same proxy group, we reach very different calculations of the proxy group's average capital structure, with hers showing an average of 52.5% equity and mine showing an average of 44% equity. The reason for this distinction is that RMP uses the average capital structure of the operating companies within the proxy group companies, which inflates the equity portion of the capital structure. This approach is inappropriate for several reasons. First, to maintain consistency, if we use publicly traded holding company data to determine the cost of equity, we should also look to the holding company capital structures to inform the appropriate capital structure for RMP for rate-making purposes. To do otherwise amounts to cherry-picking the results. Second, the fact that the capital structures are markedly different between the proxy companies and their subsidiary operating companies can largely be explained by the concept of double leverage. Double leverage refers to a situation in which a holding company uses debt to invest in the equity of a wholly owned subsidiary. Since the subsidiary also has its own debt, the result is often called double leverage. In the case of regulated utilities, the holding company can borrow money at a relatively low rate, send it to the subsidiary in the form of equity, and earn a much higher return. To the holding companies, these dollars are called debt. To the operating companies, these dollars are called equity. This allows holding companies to easily earn a high equity return while not actually investing equity capital. This unfair arrangement results in an excess return for shareholders at the expense of customers, but moreover, it distorts the results of Ms. Bulkley's capital structure analysis. In this case, though, the average capital structure of the proxy group is essentially identical to RMP's forecasted actual capital structure. As the Commission has heard from other witnesses, this is largely due to the accrual of wildfire liabilities and the payments of dividends to RMP's parent company. While I would still recommend using the average capital structure of the proxy group to set RMP's capital structure, even if RMP's capital structure was 50% debt and 50% equity, the fact that RMP expects customers to pay a higher weighted average cost of capital, or WACC, than its actual cost of capital is particularly troubling. Specifically, I find it telling that Warren Buffett is unwilling to, quote, throw good money after bad, end quote, and refuses to infuse the equity needed to improve the company's leverage. If the company's owner is unwilling to make this investment in his company, then neither should customers be saddled with it. The company's proposed capital structure simply results in exacerbating the excess wealth transfer from customers to shareholders, and it does not result in overall capital costs being minimized to their lowest reasonable level. Consistent with RMP's actual capital structure, as well as the average capital structure of the proxy group, I recommend a capital structure consisting of 56% debt and 44% equity. In closing, my recommended ROE of 8.8% and recommended capital structure of 56% debt and 44% equity yields a weighted average cost of capital of 6.81% at the company's current cost of debt of 5.21%. This still allows ample headroom in the WACC if the company's cost of debt were to slightly increase to still be a lower overall rate of return than what the company proposes at a WACC of 7.43%. This concludes my summary. Thank you.
Thank you. Before we take the break, just make sure Ms. King doesn't have any clarifying or other questions.
I do not. I would tender Mr. Garrett for cross-examination and questions of the commission, but understand we'll do that after the break.
Yes, we'll take now a break. We'll be back at 10 minutes to the hour. And the next item of order of business is the cross-examination by Mr. Saban of Mr. Garrett.
Thank you, Mr. Chair. Mr. Garrett, my understanding is you have in front of you your direct testimony.
I do.
Would you open up to page 4 with me, please?
Okay.
There's a chart there at the top, figure DJG-1. Do you see that?
Yes.
This, you set forth in the top half of that chart, I take it, the results of the models you performed. Is that right?
Yes.
And you use that information to set up the model range that's in the lower half of that chart, correct?
Yes.
So in other words, the 7.6 comes from your DCF model, open paren, sustainable growth, close paren, right?
Yes.
And the 8.8% comes from your CAP-M, open paren, add proxy debt ratio, close paren, right?
That's correct.
Okay. So within that range, for a moment, I just want to talk about conceptually, without focusing on that range, how is it that you, in performing your duties when you appear in these cases, how do you determine within a range of results where the utility that you're dealing with in the particular rate case ends up in that range? In other words, why in one case might that utility be at the low end of the range? Why might it be in the middle? And why might you put it at the top of the range?
Well, that's a good question. It's not the exact same in every case because the situation's a little different. And just briefly, like several years ago when we had the historic low interest rates, I would run the CAP-M model the same way I do now, but the results would be close to like 7%. But at that time, I didn't necessarily feel like that would be a reasonable authorized ROE for those companies. And so I wouldn't recommend that as the authorized ROE, even though it might be in like a cost of equity range. So it's just taking it on a case-by-case basis. I do tend to put more emphasis on the CAP-M results than DCF results, even in this case when they are generally higher, actually. But just because I think from a modeling standpoint, the CAP-M is superior to the DCF for several reasons. So in this case, that 8.8% result was the result of the CAP-M model. And since I am recommending a capital structure that is equal to the proxy group capital structure, for that reason, I put more emphasis on that 8.8% in this case, which just happens to be at the top end of the modeling range.
Yeah, so let me make sure I understand. What specifically would you say are the factors in this case that you considered or you looked at to decide that within your range, you'd put Rocky Mountain Power at the very far extreme, the upper end of the range in this?
Well, I think, again, like I said, because of that CAP-M result. So in other words, if the DCF model had produced a 9.5%, I still might be recommending the 8.8% in this case because I'd favor I'd still show the range. I know we have a range of 8.8 to 9.5, but I'm going to recommend 8.8 because of that CAP-M result and favoring the CAP-M more than the DCF.
So if I understand you're saying, generally speaking, you have more confidence in the CAP-M results and tend to be more swayed by their outcomes than you are by other models.
Well, I do, except I'd have to go back and reference what I just said, a few minutes ago about describing the market several years ago when those CAP-M results were producing very low indicated cost of equities. In my mind then, yes, I think that's probably an accurate cost of equity estimate, 7% for a utility when we had the very low interest rates. But under the totality of the circumstances, I would recommend a gradual change in the authorized ROE instead of coming in and recommending an authorized ROE of like 7%. Even though I do like the CAP-M conceptually more, under that unique circumstance, I wouldn't make a recommendation that was equal to the CAP-M.
All right. I want to talk about another topic briefly. You talked about capital structure in your testimony as well as in your opening statement. We've heard from Ms. Bulkley, we've heard from a number of others, and we've heard from Dr. Woolridge, and we'll hear from Mr. Coleman tomorrow. Mr. Woolridge testified in response to a commission question about what he saw was kind of the average makeup of vertically integrated utilities capital structures, and he testified that it was about 50-50. What I want to know is, I understand from your testimony, if I've understood you this morning.
Objection, I'm sorry. Is that the holding group or the operating group? I don't believe his testimony was the operating group was 50-50.
No, I think he was testifying about the holding group and that he applied the holding group capital structure in his testimony, is my understanding.
Does that resolve your concern, Mr. Moore?
Yes.
Okay, thank you. You may continue.
Maybe I should lay a little bit of groundwork first. My understanding is you have, for purposes of determining the proxy group, your testimony, you expressed that you believe it should be at the holding company level, correct?
Yes.
Okay. So I'm not asking you to go into Mr. or Dr. Woolridge's testimony in depth. He was asked a question by the commission about what he thought was about the average for his analysis, and he said he thought it was 50-50. And I'm not trying to put words in his mouth. He definitely did not say 44 or in the low 40s where you are. And I guess what I'm wondering is, can you tell me what you view to be the differences between what you've done and what Dr. Woolridge did, if you know, as you've looked at the proxies, holding companies, and come up with the differing results?
Well, yeah, I think an important distinction, maybe Randy was, or Dr. Woolridge was rounding, or just, I don't know, maybe referring to the subsidiaries, but the more important metric is that the proxy group that both Ms. Bulkley and I have used in this case, their average equity ratio is 44%. And that's really important because if you're conducting the CAP-M, you need to adjust for the capital structure differences between the utility you're studying and the proxy group you're using, either through adjusting the indicated cost of equity, which is the 8.8 versus the 8.2% in this chart, or in the context of a rate proceeding, having an imputed capital structure that is equal to the proxy group. So I don't think, as far as what Dr. Woolridge said about the 50-50, I mean, that wouldn't really matter it wouldn't be more directly relevant what other utilities outside the proxy group are doing. We have a proxy group we're using in this case. We got their betas and growth rates and dividends and stock prices from that group. I got my capital structure from that group too.
And Ms. Bulkley, it's true, did it both ways. Because you and others expressed that using an operating company approach for determining the proxy group, you didn't like that. She did it the other way as well, with a holding company group, proxy group as well, right?
I think she may have shown the results of both.
Right, and in both cases, in her testimony, using her analysis of the holding company as well as the operating company, both of those equity numbers were above 50%, isn't that right, in her testimony?
I don't think that could be right. I don't think, even in her rebuttal testimony, she was challenging I got my data source is value line, and these are the reported. Value line. Now, I think the distinction there is to make, she may have been using market values, whereas I'm using book values, but I don't think she challenged the reported book values from value line that I used to get to that 44% equity.
Right. She uses book when you're looking at book value, and market when you're looking at market. And the disagreement between, as I understand it, between you and her is you use book value data and also market value data in your analysis. Isn't that right?
I think what she would say is, what she has said, is that we're using book value for capital structure, but market value for other aspects of the modeling, stock prices, for example, in the DCF model, which is what we've always done in utility rate making. We use book value of the capital structure to set rates, the authorized rate of return and rates. We have to use the market value, of course, for these models because they couldn't work otherwise.
That's what you've done. That's not what all people in the industry do, right?
Well, Well, yeah, the way I described it, everybody uses book value capital structure to determine rates. To determine rates, yes. Now, she is using market value capital structure for this comparable analysis to get perhaps to the 50% or above 50% equity that you referred to.
All I guess I'm trying to understand is the difference of opinion between you and her is she's done it both ways, as you have. She's used holding companies and she's used operating companies. The difference of opinion lies in whether it's appropriate to use book or market value data to determine these comparables, right?
I think that accurately reflects the difference in our opinions on that.
Okay.
Yeah.
Just one more thing. I think you testified on the issue of double leverage here in your statement about the risk that a holding company or a parent company can be funneling money down to, on a debt basis down to its subsidiary operating utility and somehow earn twice on the money that it's basically investing. Were you present when Ms. Koblia testified in this case?
I wasn't present, but I watched a recording.
Okay, did you hear her testify that it hasn't been since 2010, I think if that's the right year, since Berkshire Hathaway companies or the parent corporations have sent money down to the operating utility company level?
That's a good point. I do remember her saying that. When I was talking about double leverage in my summary, I was not referring to Pacificorp and Berkshire. I do bring up that argument sometimes in cases like my home state of Oklahoma, where there's OGE Energy Corp and OG&E, the subsidiary, just a 1-1 relationship, and there's this big discrepancy in their capital structures. I brought up double leverage in the summary because more to rebut Ms. Bulkley's strategy of relying on these operating subsidiary capital structures for her analysis.
So just so we're clear, there's no relevance on the double leverage side to your hypothetical of holding companies passing money down to the operating company in this case. That's not what's going on here.
Objection calls for a legal conclusion as to whether something is relevant or not.
I'm happy to rephrase if that's helpful.
Yes, I was going to ask you to rephrase it.
Mr. Garrett, I think you just said that you weren't saying that is happening here. I just want to confirm. You agree that in this particular proceeding and in these companies that we're dealing with here, there isn't an instance where we're not dealing with a situation where the holding company or the parent company is passing money down to the operating utility and in some ways potentially earning double leverage, right?
That's correct. I did not make the double leverage argument in this case as it relates to Berkshire and Pacificorp. I brought it up in the summary to rebut Ms. Bulkley's capital structure analysis and using those other holding companies.
Understood. Thank you. That's all I have.
Are there any other, Mr. Moore has questions.
Just a clarifying question with regard to Dr. Woolridge's statement about the common equity of the vertically integrated electric utilities. Do you have Dr. Woolridge's testimony up there?
I believe I do in this volume.
Could you turn to his direct testimony, page 28?
Okay, I'm there.
Starting on line 604, Dr. Woolridge discusses the average capital structure of the proxy groups. Isn't that true?
Yes.
And he has the average structure of the proxy group around 40%. Isn't that correct?
Yes, just more specifically, he says the average common equity ratios for the electric and Bulkley proxy groups were 40.9% and 40.6%.
Thank you.
Thank you, Mr. Moore. Any other cross? We'll go back to Ms. King for redirect.
Thank you. Just briefly, Mr. Garrett, do you have before you the book of exhibits that contains Ms. Bulkley's exhibits?
I believe I do.
Okay, so maybe take a moment to find that, and I'll point your attention to her exhibit AEB 14. And we have, Mr. Chair, permission to approach to help the witness.
Permission granted.
Thank you. And in the meantime, we also have copies, should the commission and council want, for ease of review.
Sure, let's pass those out. These are already exhibits admitted into evidence. Okay. Ms. King, I think we need, oh, no, we don't. Commissioner Harvey was hoarding it. We're good, we're good.
This is a different one.
Oh, okay.
Thank you. And so, Mr. Garrett, do you have before you AEB 14?
Yes.
And I've also placed before you a copy of your exhibit, which has been admitted into the record already, DJG 13. Do you have that handy?
Yes, I do.
I believe I just handed it to you.
Oh, you oh, okay. Well, then I do.
Okay, wonderful. In your conversation with Mr. Sabin, you had a conversation about whether you were making the argument about double leverage to either, as you described, highlight the difference in Ms. Bulkley's use of operating companies versus your reliance of holding companies. Do you recall that discussion?
Yes.
And so just as a foundational question, you used the same proxy group as Ms. Bulkley did you not?
Yes, the exact same.
Okay. And if we can turn, let's start with DJG 13. And that there shows your calculation of the debt ratio of the holding companies in Ms. Bulkley's proxy group. Is that right?
Yes, that's right.
Okay, so now just for comparison's sake, to look at Ms. Bulkley's on AEB 14, and we see that she too calculates the capital structures of the companies in the proxy group, but uses the operating companies, right?
Yes, she has a separate sheet which shows like every one of all the operating subsidiaries, but she's consolidated the data on this sheet, but it does represent the operating subsidiary debt ratios.
Now, I believe it would,
It represents the operating subsidiary debt ratios, but it would have been, I should just say capital structures.
and I heard you when you said that it wasn't the intention of your use of double leverage in your summary, but have you performed a study of whether any of these operating companies in the proxy group that Ms. Bulkley relies on, have you performed any study of whether they engage in any double leverage with their holding companies?
Well, probably for, well, it looks like for quite a few of these, if I'm involved in a particular case with one of these holding companies and their operating subsidiaries is the applicant in that case, and there is a large discrepancy between the debt ratio that the subsidiary is proposing versus the debt ratio that their holding company has, I will sometimes specifically bring up the idea of double leverage between those two companies, in addition to focusing again on whatever proxy group we're using in that case. So like for example, my home state of Oklahoma, I know that's happened with OGE Energy Corp., which is the parent, OG&E is the subsidiary. Same with, American Electric Power and PSO and their various subsidiaries. So I recognize that I've probably done that analysis with several of these companies.
And so while not impugning Berkshire Hathaway and Pacificor for engaging in that kind of behavior, it's possible, right, that some of the companies upon which Ms. Bulkley relies in her proxy group relying on the operating companies, that has an inflationary effect on the capital structure that she achieves as the average.
Objection, I don't think he said he actually knew, he said it's possible. If she's only asking if it's possible that that could exist, I guess that's a fine question. If she's actually suggesting that that did in fact have an inflationary impact, I think I need to know whether he actually knows that.
I thought she was asking as a hypothetical, and,
If it's just hypothetical, then
but if you want to know if he knows that, then please just rephrase the question, Ms. King.
Sure. And so I believe Mr. Garrett's testimony was that for OGE in his home state of Oklahoma, that is the case, that there is double leverage there. But for the remainder of the proxy group, is that possible that they too have double leverage, which could inflate the results?
Well, I think to be more clear, I think it's not just possible, we see in the numbers, that has to be the case. The difference between the ratios, sorry if I misspoke earlier, but seeing the numbers as they are next to each other, that has to be happening. Based on these, so it's more of a fact than an opinion. With all of these companies, now, earlier when I was discussing, yes, in an individual case, I will just focus on the company that I'm studying. Of course, here, we're using it for a different issue, but we see the big discrepancy between these same companies, their holding companies' average debt ratio is 56%. For the operating companies, the average debt ratio is 47%. So that is double leverage by 9%.
Thanks, Mr. Garrett. And then one more question. In your cross-examination from OCS counsel, Mr. Moore, he and Mr. Sabin actually asked you about Dr. Woolridge's analysis. And do you know if Dr. Woolridge had conducted a study with more than one proxy group?
As I recall, I believe he did.
Okay, thank you. I have nothing further.
Thank you, Ms. King. Any recross, Mr. Sabin?
no, we're good, thank you.
Okay, we'll turn to Commissioner Harvey.
I'd like to ask just a couple of clarifying questions about the models that have been referenced, the DCF and the CAPM. I don't want to go too much into the detail of the models, but a key feature of both of them is that they have an infinite time horizon. Is that correct?
Yes, in the constant growth DCF model, or even if you use a multi-stage, that final terminal growth stage will contemplate the idea of perpetuity. And in the CAPM, I would say the same with the equity risk premium estimate. I've conducted basically a DCF analysis on the entire market, which still has to have that terminal growth rate that contemplates infinity. Yeah.
So in these hearings, there have been quite a bit of discussions about what are reasonable growth rates to assume for the specific company of the analysis. You've participated in some of those in your written testimony, and you remember hearing those in the hearing?
I do remember that discussion,
All right.
yes.
So if a company, this is just hypothetical, could grow faster than the economy, either the individual country or the world economy, forever, what would the models predict that, or would the models predict that that company would eventually be larger than the economy of the entire world?
Yes, it mathematically has to be that way. If I don't know if that wouldn't come out in the model result. The model result would just be kind of high, the CAPM or DCF result. But just the mathematical, you take I actually used to do this calculation. Like when Ms. Bulkley conducts her equity risk premium analysis, she lists all companies in the S&P 500, which is about 500 companies, does a DCF analysis on each one. Well, sometimes, maybe not in this case, could have been a prior case, she'd have a long-term growth rate of like 75% for Amazon. And that's probably because a Bloomberg analyst thinks that next year Amazon's earnings are going to go up by 75%. I don't know, maybe if they had a bad year the year before or something, it could in 1 year. But I would actually do the math. I'd take like Amazon's earnings grow it out over, and in like 20 years, it would be like $30 trillion or something like that. It would surpass GDP. That maybe exact scenario didn't happen in this case, but I have done the math on that before, and it's crazy how fast it can compound.
Okay. Would you agree that in the short term, companies may or may not grow equal to the economy that they're in?
Oh, definitely. A lot of companies' earnings growth are far ahead of GDP, especially the big ones, Amazon, Apple. Over the past 20 years, they're kind of in their really high growth periods. Or it could be lower in a given year. It could have a bad year and it be less than GDP. So certainly from year to year, individual companies' earnings could fluctuate. And for a really big company like Amazon, it could surpass GDP for quite a few years, even a couple decades. But for a regulated utility especially, I don't think it's reasonable to assume that their earnings and or dividend growth could surpass GDP year after year, every year over the long run.
And I've asked this of at least one other witness, but in your opinion, is a regulated, vertically integrated electric utility generally more or generally less risky than a market average?
Well, I think the answer is less risky, and I think it's more of a, probably closer to fact than opinion. I mean, it can be objectively measured through the beta term. Though sometimes we do see some utilities recently with betas that do go barely over 1. I've never seen the average beta of a proxy group yet be higher than 1, and this is using value line betas, which use an adjustment that, in theory, I would say it's one of the highest adjustments. You can make an argument that value line betas are too high. I use value line betas, and so does Ms. Bulkley and many other witnesses. But yes, I think we have an objective way to say that regulated utilities are less risky than the market average.
Thank you. That's all the questions I have.
Commissioner Clark.
No questions, thank you.
Mr. Garrett, I have a couple of questions. I want you to turn to page 9 of your direct testimony and explain to me the difference between awarded returns and cost of capital being different concepts.
Well, they are very different concepts. Ideally, the numbers between those two would be pretty close to each other, but the cost of capital is something that's estimated for any particular company using a variety of financial models, in this case particularly the CAPM and DCF model, which have been around now for decades. So analysts and managers and investors have been using those models to estimate cost of equity for a long time and will continue to, I imagine. The awarded ROE is just simply what someone says it is. You know, they could say it's 20%, they could say it's 2%. Those would be unreasonable.
So an awarded return is what a regulatory commission would set and grant as a return for a regulated entity. Is that correct?
Yes.
And your understanding is that awarded returns are set through a regulatory process and involve other factors that may not be just objective market drivers. Is that correct?
Oh, that's absolutely correct. I mean, a lot of times they're the results of settlements, you know, which could, you know, it's pretty common knowledge that without discussing any specific settlement, that utilities in general are often willing to give up other things in return for a higher ROE.
So historically, I guess what I'm trying to understand is, do you believe that commissions have set awarded returns significantly higher than the cost of capital?
Yes, and I used to have a pretty good portion of my testimony kind of showing that, and I think some other witnesses in this case have discussed that too, but I think it's probably closer to fact than opinion. the opinion would come in and how much you think it's overestimated, but I think it's pretty clear that that's been happening for probably since the beginning.
And
just
is
in
it your
general.
opinion that a regulatory commission should try to set the awarded return close to, or if not equal to, the cost of capital?
Yes, I think that's what Hope and Bluefield indicate, as I'm discussing here on page 9.
Referring to the Supreme Court cases on,
Right, and I guess if to kind of play devil's advocate, you could say that, you know, you might want to allow for a little bit of a cushion for utility companies, but their cushion is quite large, I would say, on average. And even in my recommendation in this case at 8.8%, I think would still be very fair.
just turning to I know you rely more on the CAPM analysis in your testimony, but I want to understand, with respect to the DCF modeling, your principal objection to Ms. Bulkley's analysis of and use of that model is that she presumed that company earnings would exceed GDP and grow at a linear pace in perpetuity. Is that correct?
Yes.
And what is your position with respect to any company's ability to grow at a pace greater than GDP in perpetuity?
I think it's mathematically impossible. Now, one way to say is if we're thinking about infinity or perpetuity, it's so existential that it's kind of hard to discuss. But even if we said like 100 years, that's going to be really hard for any company to do that. At one time, you know, it's like every acorn grows to an oak tree. I mean, you can start out really small and you have these periods of high growth, maybe Walmart in the 80s or something. But now Walmart's got to compete with Amazon and Target. It's just hard to keep growing once you're already that big, or else you take over the world. And in our economic ecosystem, fortunately, competition doesn't allow that to happen.
And so in your use of the DCF model, you used the annualized GDP growth of what? Was it 3.8%?
3.8% is the Congressional Budget Office's projection of, I think, over the next 20 years, the average nominal annual GDP growth.
And what did Ms. Bulkley use as her projected growth rate in her DCF model?
I think on average, the average for the proxy group, I think was a little bit in excess of 6%.
Okay. I have a couple of questions about the CAPM analysis, particularly with respect to the equity risk premium. Let me turn to those. It's no secret, I'm in my first year of being on this commission, so I may not have the familiarity that others do with the authorities that you cite to provide equity risk premium results. You cite 3, and I'd like just for you to give me a little bit of background about, I think if you looked on page 39, and then throughout your testimony, you refer to these different individuals or professional organizations, business schools that refer to and establish an equity risk premium. It's my understanding that Ms. Bulkley, in her analysis, uses an ERP of 8.21%.
Right.
And you've come up with an average based upon, well, you came up with 5.2%, but the average of yours and 3 other entities or individuals is 5.0% for an ERP.
That's correct.
Okay, would you tell me just very briefly about the IESE Business School Survey? Tell me about that organization. I'm trying to understand. I think you're saying that the well-respected authorities in the financial industry have come up with significantly different ERPs than Ms. Bulkley does. That's your testimony, correct?
Yes, that's right. One of the, the equity risk premium is important for all investors and managers. It's a metric that many people and institutions want to be able to estimate, not just us here.
Yeah.
So it makes sense that there are expert surveys conducted on this, and that's one source that investors can consult. And this IESE Business School survey has been conducted annually. It actually covers multiple companies. Of course, I'm just focusing on the U.S. metric, but I think there's more than 1,000 survey respondents, and these aren't just people off the street. They are experts. It's CEOs and CFOs around the country where the survey is asking them their opinion of what the equity risk premium is, as well as the risk-free rate and some other metrics too. But the average result from these expert survey respondents in their most recent survey was 5.5%, which, again, as we go through these other sources, that might be a little bit bullish. In fact, that's one of Dr. Demoteran, who will get to, his criticism of expert surveys is actually, if anything, they're too high. But I go ahead and include it because I think it's still a good data point to look at. Then this next source, Kroll, you might be more familiar with the name Duff & Phelps. They changed their name recently, so
Right.
They're a very well-respected international corporate finance advising firm. If they get this number wrong, people are going to know. Their own clients are going to know. They can't be too far off on it. Recently, one criticism of this is they just go by like 50 basis point increments, or maybe 25 basis points. It's not a scalpel precision estimate that they do like Dr. Demoteran does, but still, they're currently at 5%. And now we have Dr. Demoteran, who I would say is probably one of the world's leading minds on especially this particular issue. In other areas of
And
finance
is he a
too, but
professor, or what does he do?
he is a professor at the NYU Stern School of Business.
Okay.
And he's a household name in finance. So like in my MBA program, my professor's teaching me, he's referring to Dr. Demoteran in his studies. So
I must have gone to MBA school before I learned of Dr.
maybe so.
Demoteran.
Well, Demoteran is a common East Indian name, but if you Google Demoteran, there's just one guy coming up. It's this guy. So every month he puts out his average equity risk premium. He uses different variations of ways he can get to it. So I take an average of his 5 different variations that he uses, and I present one of them in my testimony. Essentially, is the model I present. I learned from him. And so his average for the most recent month, for December, or maybe would have been November, but 4.3%.
Okay, all right. That's helpful, and I can obviously do my own research about these experts, if you will. But I guess what I want to know is are these, in your viewpoint, you've already said with Mr. Demoteran, one of the leading minds on this subject, are there other reputable surveys or reports that we would get higher results that would support a ERP closer to Ms. Bulkley's 8.21%?
Not that I'm aware of. Could you find somebody out there? Probably so, especially another utility ROE witness, I'm sure. But as far as, I think the other sources that were cited in Dr. Woolridge's testimony and some of the other witnesses, I think it seems like from my recollection, were all closer to this result. I'm sure if you looked enough, you could find something that maybe is closer to Ms. Bulkley's, but on average, I think it's going to be a lot closer to 5% than 8%.
Okay, thank you. You've recommended that this commission adopt a capital structure that reflects the company's true cost of equity, correct?
Adopted a capital structure that reflects, the optimal rate-making capital structure, which I think is using the proxy group's capital structure is a good indication of that.
But you recommend 44%.
Yes, 44% equity ratio, which I would recommend regardless of the company's actual capital structure, and that's my practice in rate cases.
But 44 point some percent is what it's projected to be in 2025 during the test year, correct?
Right. In this particular cases, those numbers essentially are the same, and so I think it's even another strong data point to show that that's the capital structure that should be adopted for rate-making purposes. And then the company can, as I understand it, operate at whatever capital structure it deems prudent. But for rate-making purposes and setting the authorized rate of return, that's why I refer to it as a rate-making capital structure. That's the one we should use.
Great, thank you for that clarification, that's helpful to me. If the commission were to set the capital structure at 50%, correspondingly, there would be an impact upon the debt structure. What is the impact that you think would be felt or experienced by customers if the commission were to set a hypothetical capital structure at 50%?
Well, all else held constant would result in higher rates. And I think that the other capital structure is more appropriate, it's not just because the answer is lower, although that is what it would be in this case, but, you know, in the competitive marketplace, Amazon, Walmart, all these companies, they're trying to minimize their weighted average cost of capital. They have a natural financial incentive to do that because that's a profit maximizing thing to do. So they have this natural incentive to minimize capital costs to their lowest reasonable level. Utilities don't have that same incentive under this regulatory model, and that's where the commission can step in it's the most fair result if that weighted average rate of return is minimized to its lowest reasonable level. In this case, a capital structure, 44% equity, does that, in my opinion.
Okay, and my last question or series of questions is, Ms. Koblia suggested, I believe, that the company's proposed ROE and capital structure would be helpful, I'll use that word, to attract capital and maintain credit ratings. If we were to adopt your proposed capital structure and ROE, what impact do you think that would have upon the ability to attract capital and maintain credit ratings?
In the history of U.S. utilities, I'm not aware of certainly any relevant example, maybe like 3 Mile Island or something, but where a utility hasn't been able to attract capital or remain above investment grade. I don't know of one time in which it's happened. So under my recommendation, assuming that the company operates the company in a prudent and efficient manner, they should still certainly be able to attract capital and maintain an investment grade credit rating.
So they are currently 3 steps above junk bond rating, right?
Yes, that's correct. Baa1 and BBB+. That's right.
Do you think they would, we're asking you to read a crystal ball here, but do you think there's a significant risk that they would suffer at least one level of credit downgraded at 8.8% ROE and a 44% capital structure?
Well, it's potentially that could happen, but the narrative that they try to create is that there's this direct link between a commission decision and their credit ratings, and they're just passive players in all of this. I mean, they're running the company. Every decision they make, every check they write influence the metrics that the credit agencies use to assess their credit rating. So it's incumbent on the company to achieve the credit rating it can. Now, certainly if an awarded ROE was just so punitive, again, not in history has this happened, eventually they could say, hey, we're as lean as we can be, we're managing this company as best we can, and we just simply can't, we're junk bond now, but that's never happened. So is there a slight risk of maybe a 1-notch downgrade? Again, I would say a lot of that is on the company management too, potentially, but it would affect their embedded cost of debt so minimally, I would think, that what I'm proposing here still results in the minimized capital cost. So ratepayers would gladly, we're paying the cost of debt, customers are anyway, we'll gladly pay a few more basis points in the cost of debt to achieve a lower weighted average cost of capital. Anybody would do that. And like I said, in the real world, that's what they do all the time. I mean, in the competitive environment, you're trying to minimize that capital cost.
I don't know if this was in the scope of your knowledge and experience, but you stated the embedded cost of debt would not change. What would you think would be an approximate basis point increase by one credit, by the downgrading of one level of their credit rating?
Well, I think Ms. Cobley had said something like 85 basis points, but I think that was an estimate from, I'm not sure what that was from, but that would just be, I suppose, even though that sounds like a lot, on the newest debt. I mean, the company has all of its other debt, and calculating the embedded cost of debt is essentially more or less taking an average of that.
Sure. So it'd have a minimal effect on their overall cost of debt, is your viewpoint?
Right, 10 basis points, 20, I'm not sure, but then that's just the cost of debt portion.
Sure.
Now we have our cost of equity portion. I mean, it's still, the way the numbers work out, it's, and I think I mentioned in my summary too, the weighted average, the actual numbers. We should be seeking to minimize capital costs to their lowest reasonable level, not their lowest possible level certainly, but their lowest reasonable level, which my recommendation does compared to the company's recommendation, even with the potential of a one-notch downgrade, which again is largely in their control too.
Okay, thank you. I have no further questions. Mr. Garrett, thank you so much for being here today. And, Ms. King?
Just very briefly, if I may.
Yes.
Thank you. Mr. Garrett, when Chairman Fenn was asking you questions about your reliance on the CAP-M, are there reasons why you place an increased reliance on the CAP-M over, let's say, other models?
Right, yeah, and I've been consistent about that. I favored the CAP-M when it was producing lower results in the DCF, and now when it's producing higher results in the DCF, I still favor the CAP-M because, it led to a Nobel Prize for the guys that created that. So it was a groundbreaking discovery in finance and investments, and it's the only model that, well, compared to the DCF, that actually assesses market risk. So even Hope and Bluefield, they're talking about risk. The CAP-M directly measures that, and more importantly, its impact that market risk has on individual companies. The DCF originally is a price model. It's solving for price. We've rearranged it algebraically to solve for the discount rate, but it's more of an implied cost of equity. Also, there's circular reference issues. If you use the DCF to set the ROE influences prices and dividends, and then you're in the circle. The CAP-M does not suffer from those shortcomings. So for those reasons, I like the CAP-M a little bit more than the DCF.
Thank you. That's all I have.
Thank you for that clarifying question, Ms. King. I appreciate that very much. Okay, Mr. Garrett, thank you for your testimony. You may be excused.
Thank you.
So I believe Ms. Anderson is next. Is that correct?
Yes, that's correct.
And I think based upon the estimate on Cross, we could do Ms. Anderson and then go to lunch. Does that sound reasonable to you, Mr. Saban?
It does.
Okay. Mr. Moore, we'll turn to you.
The Office of Consumer Services calls Ms. Allison Anderson to the stand and asks that she be sworn.
Thank you, Ms. Anderson. Would you raise your right arm? Ms. Anderson, do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you very much. You may be seated. Go ahead, Mr. Moore.
Ms. Anderson, could you please state and spell your name for the record?
My name is Allison Anderson, ALYSON, ANDERSON.
What is your business address and how are you employed?
My business address is 160 East, 300 South, Salt Lake City, Utah, and I am employed by the Office of Consumer Services.
In what capacity are you employed?
I am a utility analyst.
In your capacity as a utility analyst, did you prepare and cause to be filed on October 17, 2024, direct testimony, and that you prepare and cause to be filed on December 4th, 2024, sir, rebuttal testimony in the instant case?
I did.
Are there changes or corrections you'd like to make to your written testimony at this time?
There are. Go ahead.
Please.
It's in my direct testimony on page 6, line 116. At the end of that sentence there, 116, there should be a space between fund and in. And then continuing on page 6 at line 129, there's a random period at the beginning of that sentence, so strike that. And then the final one is on page 14 at line 300. At the beginning of the sentence is the word or, strike that, and replace it with the word of.
With those changes, if I ask you the same questions as is presented in your written testimonies, will your answers be the same today?
They would.
At this point, the OCS moves to admit Ms. Anderson's direct and sir rebuttal testimony.
Without objection, Ms. Anderson's direct and sir rebuttal testimony will be admitted.
I also had rebuttal testimony. No, I think Mr. Moore incorrectly. I had direct rebuttal and sir rebuttal testimony.
I missed that.
For the,
I would like to move for the admission of the rebuttal testimony as well.
okay, the direct rebuttal and sir rebuttal testimony of Ms. Anderson is admitted. They are, the testimony is admitted, yeah. I'm not sure my subject verb agreement was right, but their testimony is a singular, so I'm good.
Have you prepared a summary of your testimony you'd like to provide at this time?
I have.
Please proceed.
Good morning for a few more minutes. My testimony introduces the Office of Consumer Services, or OCS, witnesses. I also provide the OCS's policy position on 3 issues. First, Rocky Mountain Power, or RPM's, proposal to recover excess liability insurance premium costs through a separate rider, the Insurance Cost Mechanism, or ICA. Second, Rocky Mountain Power's proposed voluntary renewable energy credit, or REC option program. And 3, Rocky Mountain Power's energy balancing account, or EBA. OCS witness Bela Vostog has already addressed the OCS's policy recommendations regarding Rocky Mountain Power's recovery of wildfire mitigation plan investments and expenses, including the recovery of deferred costs in the Wildfire Mitigation Balancing Account, or WBA. Witness J. Randall Woolridge also previously presented the OCS's recommended weighted cost of capital of 7.19%, including a return on equity of 9.375%, using a 47.5% equity to 52.5% debt capital structure. Witness Donna Ramus presents the OCS's rate base and net operating income adjustments and provides the analysis behind the OCS's proposed revenue requirement. In sir rebuttal, the OCS is recommending a reduction of at least $71,858,213 in Rocky Mountain Power's revenue requirement. In direct testimony, the OCS recommended the PSC not approve RMP's proposal for an ICA to recover liability insurance cost premiums as premature. The PSC's November 15th, 2024 order clarified Phase 3 of this proceeding as the appropriate time to discuss revenue requirement and cost allocation of insurance premium costs. The OCS understood this to mean that the discussion of the ICA would be included in Phase 3. I do note that some parties have addressed it in Phase 1, but request that the Commission allow the OCS to present its case on this issue in Phase 3.
Let me just interject right here. I think that we we have had a significant amount of testimony on the ICA, but, well, let me just check. I didn't want to speak out of turn here, but I think we will allow testimony on the ICA from any party that wants to present testimony on that. It is wrapped up with the insurance issues that will be discussed in phase 3. So I'm going to answer, I broke in, I apologize for breaking into your summary, but I thought I just ought to answer and address that right now. Okay, you may continue.
Thank you. My testimony supports Rocky Mountain Power's sur-rebuttal position to have the REC option program as a 3-year pilot program that includes only a subset of customers and then evaluating participation and costs for expansion to other classes. However, I emphasize the OCS's position that in the future evaluation of the program, Rocky Mountain Power must be required to either show that the program is viable for all customers or demonstrate why it would not be discriminatory to exclude some customer classes from the program if it is proposed to be continued. I also recommended that the Schedule 74 tariff should clearly indicate the pilot program's end date and provide specific information about the timing of the evaluation and future PSC filing to potentially make this pilot program an ongoing rate schedule. Finally, regarding the EBA, I recommend that the PSC open a new docket following the completion of this general rate case. Contrary to the implication of Rocky Mountain Power witness Joelle Stewart, the EBA should not be considered a settled regulatory matter. The Division of Public Utilities, Western Resource Advocates, and even certain members of the Utah legislature have raised concerns and issues related to Rocky Mountain Power's EBA. I envision this new docket could investigate whether the EBA remains in the public interest, as well as a wider evaluation of possible design changes that could improve how the EBA functions and balances risk. Additionally, I recommend that the PSC should require regular general rate case interval to mitigate some of the public interest concerns prior to when a more comprehensive evaluation could be finished. And this concludes my summary.
Thank you. Thank you, Ms. Anderson. Mr. Moore, I'm sorry, go ahead.
Ms. Anderson is available for cross and questions from the commission.
All right, Mr. Saban, do you have cross of Ms. Anderson?
We don't, thank you.
I assume no one else has any questions of Ms. Anderson? Okay, we'll turn to Commissioner Harvey.
I'm going to surprise everyone. Well, the question I naturally would have asked you, I had asked an earlier OCS witness, so I think you're off the hook. But thank you for coming.
Thank you.
I'd like to have a short celebration now. No, he has brilliant questions. I'm just teasing him, so. All right, Commissioner Clark. Sure.
No questions. Thank you very much.
Thank you.
Ms. Anderson, I just have one question. So if, I want to make sure I understand the OCS's final position on the REC program. So you are comfortable with a 3-year pilot
Correct.
and at this point in time not being expanded to residential customers?
Correct.
And at the end of the 3 years, an evaluation of the program to determine if it can be expanded to more customer classes, including residential customers?
Yes.
Okay. Or if it should be discontinued?
Correct.
Okay. And then with respect to some questions about your position on the ICA vis-a-vis what Ms. Stewart has testified about that, I'm going to reserve those for phase 3 of the hearing. So I have no further questions.
Great. Thank you.
You may be excused. Thank you so much. Well, we all know that Ms. Ramos will take a long time, so I suggest we take our lunch break now and then reconvene at 1 p.m. Is that okay with everybody? All right, we'll be in recess till 1 p.m. I think that this is Ms. Ramos, is that correct?
Ramus.
Ramos, I'm Ms. Ramos, Ms. Ramos, okay. Thank you.
The Office of the Office of Consumer Services calls Donna Ramus to the stand and asks that she be sworn.
Thank you for your raise your right arm. It's Ms. Ramos, correct? Ramos, okay. I apologize for pronouncing it slightly off just a second ago.
It's often happens.
I'm sure. It happens to all of us, unless your name is Smith. Ms. Ramos, will you raise your right hand to the square? Do you solemnly swear the testimony you're about to give in this matter shall be pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. You may be seated. Mr. Moore?
Ms. Ramus, could you please state and spell your name for the record?
Donna Ramus, D-O-N-N-A, last name R-A-M-A-S.
Ms. Ramus, for whom are you testifying today, and what is the subject of your testimony?
The Utah Office of Consumer Services, and predominantly revenue requirement issues, as well as a recommended adjustment to a deferral.
Did you prepare and cause to be filed on October 17, 2024, confidential and redacted direct testimony and accompanying exhibits? And did you prepare and cause to be filed on December 4th, 2024, confidential and redacted served rebuttal testimony and accompanying exhibits in this case?
Yes, I did.
Are there any changes or corrections you'd like to make to your testimony at this point in time?
In my SIR rebuttal testimony, I have a minor word correction. It's on line 449 at page 22 of my SIR rebuttal testimony. I have the word traffic, and that should be tariff, so that it reads open access transmission tariff.
Other than that change, if I ask you the same questions that are in your written testimony, would your answers be the same today?
Yes, they would.
At this point, the OCS moves to admit Mrs. Ramos' direct and rebuttal testimonies and accompanying exhibits.
Without objection, the testimony, the direct and SIR rebuttal, and the exhibits are admitted.
Have you prepared a summary of your testimony you would like to provide at this time?
Yes, I have.
Please proceed.
Okay. Good afternoon, Chairman Fenn, Commissioners Clark, Commissioner Harvey. In this current general rate case proceeding, I am recommending many adjustments to the future test period presented by Rocky Mountain Power, and I have provided the revenue requirement impacts of each of my recommendations on behalf of the Office of Consumer Services. I am pleased to be here today on their behalf. I have assisted the office in numerous past regulatory proceedings, including many past general rate cases involving Rocky Mountain Power and its predecessor. I believe the first rate case that I submitted testimony here in Utah involving a predecessor to Rocky Mountain Power was docket number 9903510. With this long history in mind, I found this current case to be both unique and challenging in many ways. The company's rate case filing uses 2023 as the base year, which is then adjusted to the 2025 future test year. As is evident from the many adjustments made by the company, by me on behalf of the office, and by other interveners in this proceeding, many issues were unique in the 2023 base year that need to be addressed in determining an appropriate revenue requirement. 2023 was a tumultuous year for the company in many ways. While numerous adjustments were made in the company's original filing in going from the 2023 base year to a 2025 test year, many more adjustments were needed to ensure non-recurring costs were excluded, that out-of-period costs were removed, and to ensure that abnormal costs were properly normalized in going to a future test year. In my direct testimony, I presented exhibits containing 22 additional adjustments.
Subsequently, the company's rebuttal filing incorporated 18 revenue requirement adjustments, many of which fully or partially adopted adjustments presented in my direct testimony, as well as adjustments recommended by other interveners in these proceedings. There are essentially 6 revenue requirement adjustments presented in my surrebuttal testimony that remain in dispute, each of which I will discuss in this summary. Adoption of the capital structure and return on equity recommended by the office would result in a $34.8 million reduction to RMP's requested revenue requirement. Adoption of the adjustments presented in my surrebuttal testimony would result in a $37.1 million reduction for a combined reduction to the revenue requirements presented in the company's rebuttal filing of $71.9 million. The $71.9 million reduction to the company's request does not include the impacts of additional adjustments recommended and supported by other parties in this proceeding, which would further reduce the rate of the increase if they are adopted by the commission. I would like to note for the commission that the impact on revenue requirement that would result from adoption of the office's capital structure and rate of return on equity recommendation differs from the impact identified in FEA witness Gorman's corrected exhibit MPG-1R. Mr. Gorman's corrected exhibit did not include the office's recommended capital structure, nor did it, understandably, it didn't include the surrebuttal update to the return on equity presented by office witness Dr. Woolridge. I just didn't want the commission to look at Mr. Gorman's exhibit and think that was the impact of the recommended capital structure and return on equity. I will now briefly address each of the adjustments in my surrebuttal testimony that, as I sit here today, I believe remain in dispute. The first area I will discuss is wheeling revenues, for which I recommended 2 separate adjustments. For the first adjustment, the company based the projected test year wheeling revenues on forecasted open access tariff transmission rates, or OAT rates. The current actual FERC-approved OATT rates are known and will remain in effect through May 31st, 2025. While I understand that the FERC-approved OAT rates are subject to future true-up, I recommend that RMP's adjusted wheeling revenues for the period January through May 2025 be updated based on the actual FERC-approved OATT rate that is in effect for that period, since that rate is known. This increases wheeling revenues by approximately $6 million on a Utah basis. The second wheeling revenue adjustment involves the 500 megawatt point-to-point transmission service request that requires Energy Gateway South Transmission Project to provide service. Well, the company has included over $2 billion on a total company basis within its forecasted plan additions for the Gateway South project. It did not include the projected test year wheeling revenues for this new point-to-point transmission service customer. The company has indicated that its best estimate of the revenue to be received from this customer is $26.4 million in the test year, which is approximately $11.8 million on a Utah basis, if that customer takes service. Well, this customer's generation is not anticipated by the company to reach commercial operation until 2028 or later. The company has indicated that the customer must take the 500 megawatts of transmission service January 1st, 2025, or forfeit its rights and terminate the contract that it has with the company.
We're going to take just a break for just a second. I'm sorry. We'll let Dr. Harvey's having a cough issue. probably in mid-sentence, Ms. Ramos, but we'll ask you to continue with your summary, please.
I appreciate the
But you
breather.
you know exactly where you were?
Yes, I marked
Okay,
it.
all right.
Thank you. If the customer's rights are forfeited, the company explained that this would allow the lower priority requests to take over the megawatts that are released. I recommend that the best estimate of the revenue provided by the company, which was $11.8 million on a Utah basis, be included in the test year. Since wheeling revenues are currently trued up in the energy balancing account, any variance from my recommended wheeling revenues resulting from the Gateway South transmission project will be trued up, as will the impacts of the true-up of the FERC OATT transmission rates once the amount is known. Given the size of the rate increase being sought by the company in this case, which is largely driven by the Gateway South project and net power costs, I would urge the commission not to accept the company's likely under projection of test year wheeling revenues. The next area in dispute is the appropriate amount to include in rates for the expense associated with the overhaul of generation units. Since generation overhaul expenses can vary significantly from year to year and from unit to unit, the amount of expense included in rates has historically been based on a 4-year average. The 4-year average approach is used to ensure that base rates are not set to include either an abnormally high or an abnormally low level of generation overhaul expense. In determining the normalized overhaul expense, I recommended that the historic expenses associated with the overhaul of Craig Unit 2 be removed. The company currently anticipates that the unit will be retired in 2028, and no future overhauls are currently projected for this unit. In making this recommendation, I did not remove the overhaul expenses associated with other generation units the company anticipates retiring soon. Rather, I only removed the unit for which the company does not forecast incurring any future generation overhaul expenses. This recommendation reduced test year expenses by approximately $430,000 on a Utah basis. Moving on to legal costs, the 2023 base year included substantial expenses for the use of outside legal services and outside expert services in wildfire-related lawsuits and wildfire-related litigation. I will refer to this as wildfire-related legal expenses. This included substantial amounts resulting from the 2022 Labor Day wildfires and included the litigation of the James case, the result of which was a jury verdict in Oregon that found Pacificorp to be grossly negligent, restless, and willful, resulting in both punitive and compensatory damages. With the exception of removing some legal costs originally incurred in 2021 and 2022 from the 2023 base year, the company did not remove the wildfire-related legal expenses. This resulted in $29 million on a total company basis, or $12.9 million on a Utah basis, remaining in the test year for wildfire-related legal expenses. It is my recommendation that these costs be excluded from revenue requirements charged to Utah ratepayers. Other non-wildfire-related legal expenses remain in the adjusted test year. In prior Rocky Mountain Power rate cases, I do not recall seeing anywhere close to the level of legal expenses that are at issue in this proceeding, with the increase driven by the wildfire-related litigations. I am hopeful that the wildfire-related legal expenses incurred in the base year are not reflective of annual ongoing expense levels and do not become the norm for the company. As explained in my rebuttal testimony, if insurance amounts had not been exhausted by the payment of wildfire-related injuries and damages claims, insurance would have been available to cover some of the company's litigation costs. While it is the company's position that the amount of legal costs in its filing should remain and be recovered in rates as representative of costs going forward, I disagree. Even if the company continues to incur a substantial amount of legal costs for wildfire-related lawsuits and litigation, the Commission needs to consider if it is fair or reasonable for the company to recover these costs from its Utah customers. It is my recommendation that this not be the case. Moving on to property tax expense. The company has over-forecasted property tax expense It overforecasted it in the 2020 general rate case here in Utah by quite a large amount. In its rebuttal filing in that proceeding, the company updated its projected property tax expense, increasing the amount to $191.4 million for the forecasted 2021 test year. The actual expense for 2021 was $27.9 million less than this forecasted amount. In every year since that 2020 rate case, the actual property tax expense incurred by the company has been substantially less than the amount included in the prior rate case. In fact, the amount of property tax expense in the 2023 base year in this case was $153.1 million, which is $38.3 million less than the amount that was used in establishing the current base rates. The company has significantly overprojected the property tax expense in each year, 2021 through 2023, with the expense being overprojected by the company by $29.5 million in 2021, $32.9 million in 2022, and $28.6 million in 2023. The average amount by which it was overprojected for this 3-year period was 16.54%. I recommend that this factor be applied to the property tax expense forecast in the company's original filing in this case, resulting in a property tax expense of approximately $150 million. This is $29.7 million less than the amount contained in the company's original filing and $12 million less than the amount in the rebuttal filing. While the company did reduce its projected property tax expense in rebuttal, it is my opinion that further adjustment is needed. The company used the same forecasting methodology in its update as it used in its original filing, which is also the same methodology used in the prior rate case. Based on the comparison of budgeted to actual property tax expense, varying by close to $30 million in each of the last 3 years, it's clear the company's forecasts have not been accurate. My recommended $11.96 million reduction to the rebuttal filing would reduce test year property tax expense by $5.3 million on a Utah basis. The next issue is for the Cholla regulatory asset. Cholla Unit 4 ceased operations in 2020. In the 2020 general rate case, the company requested approval to establish a regulatory asset to defer and amortize 3 specific categories of closure-related costs. This included construction work in progress balances that were assumed to no longer be needed due to early plant retirement, materials and supplies balances that were deemed to be specific to that unit, and liquidated damages costs. The Commission approved the requested regulatory asset with the costs being amortized over a 4-year period. Since the actual stranded construction work in progress and materials and supplies balances were lower than projected in the prior rate case, the Cholla Unit 4 closure regulatory asset approved by this commission will be fully amortized in January 2025, which is next month. Now that the approved amortization is almost complete, the company is seeking authority in this case to add 2 new categories of closure-related costs to the regulatory asset. This includes approximately $100,000 for a safe harbor lease termination payment that was paid by the company over 2 years ago in March 2022. Also included is $2.3 million for estimated severance payments associated with APS employees that RMP may be required to make at some undisclosed future time as a result of negotiations with APS. At the time the Cholla closure regulatory asset was requested in the prior rate case, the company was well aware that it may incur both safe harbor lease termination costs and severance obligations as a result of that closure. Despite this knowledge, the company and 2 company witnesses addressing the regulatory asset request in that prior case, the company did not request to include these categories of costs as part of the regulatory asset that was established. If the company had intended to seek future recovery from Utah ratepayers of these costs, it had an obligation to request authority to defer the costs in the prior rate case in which the regulatory asset was actually established, and it did not do so. I recommend this late request to expand the previously approved parameters be rejected. This reduces Utah revenue requirements by about $430,000. The final area I will address in this summary is the wildfire mitigation deferred accounting. In this case, the company is seeking to recover approximately $21 million of wildfire mitigation costs that it deferred from 2021 through 2023. The company has proposed to recover this $21 million over a one-year period outside of base rates through Electric Service Schedule number 97. While the revenue requirement impacts of the 2023 Wildland Fire Protection Plan are now being addressed in Phase 3 of these proceedings, at least a portion of the wildfire mitigation costs that were deferred through 2023 remain at issue in this phase of the proceedings. It is my understanding that the amounts the company deferred in 2023 that are applicable to the currently unapproved 2023 Wildland Fire Protection Plan remain subject to review as part of Phase 3. For this phase, I recommend that the internal labor costs that the company included in the operations and maintenance expenses that are incorporated in its deferral calculations for 2021 through 2023 be removed. Simply put, the company did not incur incremental labor costs as a result of the Wildland Fire Protection Plan that were not already recovered and included in base rates that have been recovered from Utah ratepayers. In my direct testimony, I explain at length that the actual amount of total labor expense incurred by the company in 2001 through 2023 deferral period at issue was less than the amount included by the commission in the commission-approved rates in the prior rate case. I explained that the test year labor expenses that was accepted by the commission in that rate case was $501 million of expense, while the actual amount of labor expensed by the company was approximately $470 million in 2022 and $497 million in 2023. I also explained that the adjusted labor costs and resulting labor expense of $501 million in the prior rate case was based on an average employee complement of 4,892 employees. Well, the actual average employee complement was only 4,636 in 2021, 4,562 in 2022, and 4,729 in 2023. It is not feasible that the company incurred incremental internal labor expenses as part of its wildfire mitigation plan when both the total labor expenses and the employee complement have been less than the amounts factored into base rates that were recovered from Utah ratepayers over that entire 3-year deferral period. Just to be exceedingly clear for the commission, I am not recommending that any labor costs be disallowed or that the company not be permitted to recover labor costs associated with its wildland fire mitigation efforts. Rather, it is my position that these internal labor expenses that were included by the company in the deferral balance have already been recovered from Utah ratepayers. Removing the internal labor expenses from the deferral calculation is not a disallowance. Rather, it's an acknowledgement that the costs have already been adequately covered in base rates paid by Utah customers. The internal labor expenses that the company incorporated in its deferral calculations was approximately $940,000 in 2021, $1.45 million in 2022, and $3.1 million in 2023. Removal of the labor expenses from the company's deferral calculations would result in the deferral balance of $15.3 million instead of the $21 million sought by the company. Whether or not further revisions are needed to the revised $15.3 million recommended balance will be addressed in Phase 3. As expressed in the testimony submitted by office witness Bela Vastag, the office remains concerned that the company did not clearly demonstrate that other non-labor operation and maintenance expenses included in the company's deferral calculations are, in fact, incremental costs to costs already being recovered in base rates. Despite this remaining concern, the only O&M expenses removed from the deferral calculations in my exhibit are for the non-incremental internal labor costs. It's my understanding that Office Witness Vostog referred some of the Commission's questions on the deferral balance in the calculations to me. I'd be happy to respond to any questions the Commission may have on this important issue and any other issues. Thank you for allowing me to present this summary.
Ms. Ramus is now available for cross and questions from the Commission.
Thank you, Mr. Moore. Mr. Kumar, looks like you're going to conduct the cross.
Well, we have no questions for this witness.
Oh. Okay. Thank you. Does anybody else have any questions for this witness? All right. Commissioner Harvey.
So the company just did to me what I did to Commissioner Clark. All right. So on your, I guess, fourth point about legal costs, it seemed like there were multiple arguments for for your justification for the recommended adjustment. My understanding was that one, you think it's hopefully a one-off, that they won't be repeated. Is that correct?
That was my hope. I do understand there's still ongoing wildfire-related litigation, though, but it really is my hope that at some point we get those Labor Day fires behind, or the company gets it behind them, and we won't continually see this level of cost.
So I guess my question on that part of it then is how does the company determine what a reasonable trajectory to get from where they currently are to that hoped-for future in terms of what should or should not be included? Give me some of the rationale there.
Yeah, I guess first it's my view that once you remove those wildfire-related litigation costs, there's still quite a bit of a legal expense remaining in the test year that, in my view, would be more reflective of what you typically see in rate cases for this company. I haven't really seen where the company's presented, sort of that trajectory downward from this wildfire-related litigation legal expenses. But it remains my opinion that even if they do incur that level in the test year, 2025, that the commission really needs to consider if it's fair or reasonable that be charged to Utah ratepayers. The company was found grossly negligent in those cases. So whether or not those costs should be passed on to Utah ratepayers, it's my opinion that they shouldn't be. I do know the company had submitted, I believe it might have been Ms. McCoy's rebuttal testimony, that there's a lot of legal costs this year, and they project, more in 2025. But that 2025 test period litigation is largely for matters that still remain associated with these, the Labor Day wildfires and the James litigation.
Anticipated my next question, which was related to that Utah customer responsibility. And that is, well, let me back up. You're familiar with the multi-state protocol, the joint allocation that came out of that?
Yeah, I'm familiar with it. I don't know all the ins and outs of the I don't participate in the multi-state process, but in every rate case I do here in Utah, I do look at the allocation factors and try to determine if they're applied correctly as part of the revenue requirement calculations.
Okay. So with respect to that protocol, do you see any clear lines that would let the commission exclude those costs that traditionally haven't been excluded?
Yes, I do, because again, the company's been found grossly negligent and liable, and that's not my language, you get that right in the company's quarterly statements to the SEC. So just from a prudence issue, should those costs come to Utah customers, or is that something the company and its ratepayer, or its shareholders rather, should absorb? And it's my opinion that would be the case. So I'm not even sure you need to get to the point of if it's consistent with the jurisdictional allocation factors. But again, it's also my understanding that those jurisdictional allocation factors have to result in a fair and reasonable result. These have to do with hearings that occurred in Oregon, where it's my understanding that some of the liabilities that can occur in Oregon differ from what you may experience here in Utah. I mean, that's all things the commission should consider, is whether or not the current allocation factors, including that SO allocation factor that the company's applying to these costs, does still, in fact, result in something fair and reasonable for Utah customers. I'm not an attorney or a legal expert on the protocol, and I haven't been participating in those multi-state plan groups, but I'm not aware of anything that would remove the commission's authority to do what's fair and reasonable and appropriate for Utah.
Then moving to the property tax adjustment you suggest. It strikes me that you provide in both your testimony and in the summary a statement of how big the forecast error was for each of the previous years since the last rate case, and yet it seems like the adjustment you're recommending is smaller than that forecast error. Am I getting that right, or am I missing something?
The dollar amount may be a little smaller. What I did is I took for each year the company provided me its budgeted property tax expense and the actual property tax expense in each of those years. And I determined the percentage by which the company over-projected property tax expense in each of those years. And then did a 3-year average of that. And it's that 3-year average that I applied to the company's originally forecasted property tax expense. So I didn't average the dollars, it's more the percentage by which they over-forecasted.
Okay, thanks. I think that's all my questions. Thank you.
You're welcome.
Commissioner Clark.
Good afternoon. I would like to ask you some questions about the table. I think I'm in your SIR rebuttal at page 41. It's actual legal expenses, 2020 to 2023.
Yes, I'm there.
Thanks. Do you know what was in rates from the 2020 general rate case for those two categories of the FERC account 925 and then the legal expense excluding that FERC account which relates to injuries and damage expense?
If you can give me a moment, I believe I have the 925 balance in my files here. Just a moment. You know, I'm sorry I did not bring that file with me. For account 925 specifically, injuries and damages, it was a small number. My recollection is under $1 million. This is the first case that I recall out of the many I've done with this company where I've seen a large amount of legal expense in account 925, which is injuries and damages expense. Again, my recollection is it was under $1 million, but unfortunately, I don't have that file handy here.
That's okay. Do you recall the method by which the test year, by which the Rocky Mountain Power projected the test year expense for 2020?
For legal expense specifically?
Right.
I don't recall any specific adjustments being made by the company in its filing in that case, so it would have most likely been based on the 2019 base year legal expenses by FERC account, with the escalation factors applied to them.
And the escalation factors would be accounting for what, precise, inflation, anything beyond that, or?
Yeah, in past rate cases and this case, the company uses an industry-provided estimate of escalation factors based on FERC account or group of FERC accounts, and it would have been based on what was estimated for each of the FERC accounts that these expenses were recorded in.
So thank you. The account 925 expenses then take a significant jump between 2020 and 2021, and then again between 2022 and 2023. Do you have any sense of what drove the 2020 to 2021 change in FERC account 925?
I can say that they're, if not entirely, almost entirely related to wildfire-related litigation or wildfire-related lawsuits. I may have the file that gives me more specificity, but that would be confidential because it would get into specific legal matters, but it's definitely wildfire-related.
And do you know whether the driver would have been the 2020 Labor Day fires or something other than that?
If you give me a moment, I'll make sure I can see what I can answer on the record.
Thank you.
You know what, that may actually be in one of the exhibits attached to my testimony. You know, I'm sorry, I must not, I thought I had that file with me, and I don't. There was a data request issued that broke down the historic legal expenses in that account.
And the numbers in the table, I was a little confused whether these are Utah allocated numbers or total numbers. Line 832 refers to RMP's books, and I wasn't sure.
Yes, on page 41, the numbers are total company numbers.
They're total company. Okay. And so the 12.9 million that you are recommending be reduced from the company projection is the Utah allocated number, and does it represent both of these, both the FERC account 925 and the other, and the account 925 expenses?
Yeah, the breakdown of that I have on my exhibit, OCS 3.4 SR, my rebuttal exhibit. And out of the amounts in account 925, I don't remove the full balance. I only remove the portion that related to the wildfire-related mitigation. So there's a small amount remaining in there. That would be $26.6 million on a total company basis that I removed from account 925. From account 923, I made two separate adjustments. One was to remove approximately $365,000 on a total company basis, and the other adjustment removed about $2.2 million on a total company basis for the wildfire-related litigation costs that the company had recorded in FERC account 923. And the company also made an adjustment in its rebuttal filing to FERC account 923 to remove the costs that pertain to years prior to 2023 that it had rolled into 2023 on its books.
Thank you. And then regarding the internal labor issue pertaining to the wildfire mitigation deferred costs. With each of the other items, I think you gave us sort of the Utah revenue requirement impact as you've calculated it, and in your summary. And I didn't at least note one in your summary for this item, but I'm assuming it's the same as you have in your rebuttal testimony, roughly 5.681 million. Would that be right?
Yeah, that's the internal labor costs related to the wildland fire protection plan that the company had deferred. And almost the entire amount is Utah specific, because this is a work that's being done mainly to the distribution system in Utah. There were some costs that were transmission related, but the dollars amounts I referenced are on a Utah basis. And I do have an exhibit included with my testimony that shows a specific breakdown of that by month between distribution, and it also shows the portion related to transmission as well as the allocation factor that's applied to that.
Thank you, Ms. Ramis.
You're
I don't
welcome.
have any further questions.
Thank you.
Ms. Ramis, it appears that you were involved in the negotiations on a number of these items where there was an accommodation or a resolution of issues with the company on various issues that were originally included in the revenue requirement. Were you personally involved in those discussions?
For this rate case, I wouldn't say there were discussions, but I had raised the issues in my direct testimony, and then the company responded in rebuttal, and in rebuttal they agreed with some of my positions or partial agreement on some, as well as some of the division and other parties' recommendations.
Without getting into the details of any settlement discussions, where you had partial agreement, are there further discussions on resolving any issues where there was partial agreement?
Yeah, and again, these weren't the result of any settlement discussions with the company. It was just my written direct testimony and the company's response to that. If there have been discussions beyond that, I'm not aware of them at all.
All right, I was trying to figure out if you were involved in negotiations back and forth in this, but it sounds like where you've made a good point, the company acting in good faith felt like that the position was reasonable, then they had acquiesced to the reduction.
Yes, and there were, as I discussed in my rebuttal testimony, a few adjustments where the company maybe didn't fully agree with me, but I saw the validity in their response and modified my position to agree with their rebuttal recommendation.
Yeah, I saw that. Thank you. I have just a question about the wheeling revenue and the open access transmission tariff that was in place. The company used an OAT rate of $3,494 per megawatt month for the period of January 25th through May 25th, but the actual FERC approved rate for that period is $4,460.80, correct?
That sounds right. Yeah.
It's actually on page 24 of your direct if you want to turn to it.
Okay. Yeah, and I'm not disputing the amounts. That does sound right. I just didn't have the number right in front of me.
So explain to me your position on why the actual FERC rate that's in effect until May of 2025 should be utilized rather than what the company utilized.
Several reasons. The main one being is it's known and measurable. This is the amount they are in fact being charged currently. The rate in the filing was the estimate based on a prior year. I acknowledge there will be a true-up of that rate. We just don't know yet what that final true-up will be. It depends on what happens with the company's books through the rest of this year and other factors that go into that FERC formula.
But the true-up would occur after the test year, after 2025, correct?
It's my understanding there will be a true-up. The company will book an estimate for the true-up in December of this year, and then there will be a ultimate true-up of that rate that's in effect through May. I believe I cite the date that occurs. I want to say in May or June timeframe. There will be a true-up rate that goes into effect then. So it'll happen during the 2025 test year. And then I know there's a delay in how that then flows through the EBA calculations.
So help me understand, why wouldn't it be appropriate to go with the true-up rather than utilize the rate you've suggested?
We don't know what that true-up is yet. I know Ms. McCoy's rebuttal testimony presented some information on a number that differed from that $3,400 and some rate, based on if you just change one component of the calculation involving the amounts the company booked to expense for wildfire liabilities. But I haven't seen anything that shows a calculation of what the company's current best estimate of what that true-up rate is going to be yet. The company, their position is, I believe it's to continue using the estimated amount they included in its original filing, but we won't know what that actual final rate will be until sometime in 2025, is my understanding.
So do I understand it, if you use the actual FERC-approved rate, whatever true-up would be probably less, it would be more accurate to use the actual FERC-approved rate, is that correct? Help me understand.
It's accurate as far as we know that's the rate that's currently being charged and what's actually going to be billed for that 5-month period, the first 5 months of the test year. There will be a true-up, but we don't know the dollar amount of that true-up yet.
Okay.
And one of the reasons I had recommended this in this case is the commission's order in the prior rate case references that the company in those proceedings made a revision to its original transmission revenue calculation in that case based on recently approved FERC OATT rates. What I thought I was doing the same thing in this case where I was using the current rates that were in effect for this period. I guess it's more of a background on one of the reasons I pursued this adjustment. It seemed consistent with what had happened in the prior rate case.
Okay, all right, thank you. You've also recommended the legal expenses in connection with the wildfire lawsuits litigation not be included in the expenses in this case. And that's because of your conclusion, at least in part because of your conclusion, because of the results of the James verdict where the company was found to be grossly negligent, reckless, and willful, and therefore do you conclude that that should not then be a ratepayer paid expense?
That's my opinion, yes.
Do you agree, though, that there are going to be continued legal expenses associated with appeal of the James verdict and other settlement and other wildfire claims that are pending or may be pending during the test year?
Yes, I do. I know when I filed my direct testimony, I wasn't aware of the magnitude of the number of James-related cases that would be occurring during the 2025 test year. I've read more information on that in more recent SEC filings made by the company. So I'm aware there will be substantial legal costs in the 2025 test year associated with particularly the James case.
Do you have an estimate of what those may be?
The dollar amount? No, that's something that the company would have to provide.
I just wondered if there was something that you recalled from the company's filings as to an amount.
I know in response to a confidential, in a confidential portion of a data response that came in between the company's rebuttal date and when my SIR rebuttal was filed, there was a dollar amount provided. But again, that was confidential, and it was inconsistent with the different dollar amount I had seen previously in the case when looking at a document the company considered to be highly confidential instead of just confidential.
Okay.
So I really can't speak too much to the specifics, but the number has changed from what was originally estimated. That's probably all I can safely say.
I don't want to go into confidential session and disclose the dollar amount. It's not that relevant. But I guess what I'm trying to understand is you would take the same position with respect to 2025 incurred costs for wildfire litigation as you've taken with respect to the costs that have already been incurred. Is that correct?
Yes, it is. One of the reasons for the removal was that I was hopeful at that point in time that I wrote my direct testimony that that level of cost would not continue. But even if it does, I still take issue with charging those costs to Utah customers.
Okay. All right. I want to understand the recovery of labor costs. Your position is that the calculation of the deferred balance amount has already been recovered from Utah ratepayers, that it was included in the prior rate case in base rates. Is that correct?
Yes, for the internal labor cost component.
So let me make sure I understand. The $501 million was included for labor expense and base rates in the prior rate case. And your analysis is that the actual labor costs for that are at issue here are how much?
The labor costs at issue, with regards to the amount I've removed from the deferral balance? It's, I can give you the exact number, but it's a little over $5 million.
Okay.
It's provided with the exhibits attached to both my direct answer rebuttal testimony.
Okay. Let me see what else I have.
And again, just to make sure I'm being completely clear, though I've removed the internal labor costs from the deferral calculations, and each month that the company included it in the calculations. So I used Miss McCoy's exhibit, I believe it's SEM-9 in the work papers with that. That's where the company provided the calculation of its $21 million deferral balance. And as part of that, a component of the amounts that were deferred pertained to O&M expenses. So I removed the O&M expenses for the internal labor costs for each month that they were booked by the company in that calculation. So the dollar impact is a little different than just totaling those labor dollars, because you've got the interest that's applied in carrying charges that's applied in that deferral calculation.
Okay, I think that's helping me understand it, but what you're saying is that the deferral calculation, that there are no unrecovered labor costs that aren't included in the prior GRC's base rates.
Yes, it's my opinion, and as I even point out each of the dollar amounts in my testimony, that the amount of internal labor expenses that were incorporated in base rates, the actual amount the company's incurred each of the 3 years of that deferral period have been less than the internal labor expense that are already factored into base rates and being recovered from customers.
Okay. Okay. Sorry. Your second adjustment on wheeling revenues, increased wheeling revenues on a Utah allocation by $11.8 million, and that was to include estimated revenues associated with the 500 megawatt point-to-point transmission service request involving Gateway South, correct?
Correct.
In your testimony, you refer to data requests 34, where the company was asked, quote, with the currently anticipated Gateway South in-service date and the currently projected date, the required network upgrades, I think must be a word missing there, and the currently projected date, the required network upgrades, What is the company's current best estimate of the date by which the customer must begin taking service or forfeit its rights? And in response, the company stated January 1st, 2025. It's your position that the wheeling revenue associated with that point customer should be calculated starting January 1st of 2025, is that correct?
Yeah, it's my opinion that for the 2025 test year, that's the company's current best estimate of the amount of revenues it would receive during the test year. And under the contract they actually have with the customer, my understanding is the customer would have to start taking service January 1st, 2025.
Or forfeit their rights and terminate the contract, is that correct?
That's my understanding.
I should have asked this to Mr. Vale, but let me see what you know about this. One that those contract provisions were pointed out, there was a response, quote, this is on line 563 through 564 of your testimony. The customer has verbally requested information regarding extension of commencement of service, end of quote. And no further details were provided. Is it your position that even if there is an extension on commencement of service, that the wheeling revenues should be imputed to that customer as of January 1st of 2025?
It's my understanding from reading Mr. Vale's rebuttal testimony that extension of service, it sounded to me from the reading of his testimony that that's not an option because there are other entities in the queue, so to speak, that would take that service if it becomes open.
The, whatever it was, 12 or 13 other customers, is that what your understanding was? There's any of the other customers
I
that
believe,
are...
yeah. Sorry.
Go ahead.
I believe there's a long queue of customers that, and you can see the actual listing, I believe, if you go on the Oasis website that you can get to from the company's website. But I believe that's separate and different from the 12 to 13 customers.
Okay, that's helpful. I'm glad to know that. Okay. All right. I think that's all the questions I have. Let me just look at one other thing. I have no other questions. Thank you.
You're welcome.
Ms. Ramos, you can be excused. Thank you.
Thank you.
Okay, I next have the Walmart witness, is what I understand, Mr. McGovern.
It's Dr. Jamie McGovern, and she is here.
Dr. Jamie McGovern, okay. Ms. McGovern, Dr. Jamie McGovern,
Yes, Walmart would call Dr. Jamie McGovern to the stand.
okay. Apologize for concluding that a Jamie was a man's name, and that's totally inexcusable on my part, so forgive me. Would you stand up for just a second so we can swear you? Dr. McGovern, is that okay? Yes. Dr. McGovern, welcome. Would you raise your right arm? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. Please be seated.
Thank you.
Thank you, Dr. McGovern. Okay.
Thank you, Chair. Dr. McGovern, can you please state your name and spell your last name for the record?
Dr. Jamie McGovern, My name is spelled Jaime, McGovern, Mcgovern. Absolutely. M as in Michael, Cgovern.
Dr. McGovern, who are you employed by and what is your title?
I'm employed by Walmart. I am for the Western United States as Senior Manager of Utility Partnerships.
And have you provided testimony before the Utah Commission before?
I have not.
Since it's your first time, can you please provide information on your background and experience?
Yes. I have provided testimony and expert witness before the Washington Utilities and Transportation Commission, the Oregon Public Utilities Commission, the California Public Utilities Commission, and the New Mexico Public Regulatory Commission. I hold undergraduate degrees in mathematics and economics and earned my master's and doctorate in economics at Arizona State University W.P. Carey School of Business, with areas of focus in econometrics, industrial organization, game theory. And my doctoral dissertation established minimum conditions for stability in stochastic theoretical macroeconomic economies. I held the position of assistant and adjunct economics professor at several universities and community colleges in New York and Arizona. I began my career in energy at the Oregon Public Utility Commission in 2006. I've also served as senior economist and policy analyst at the consumer advocacies in both Oregon and California, and as a revenue economist for the Oregon State Legislature Revenue Office. And prior to this, well, I was just in school, sorry. That was a typo.
No problem.
Thank you. Did you prepare direct testimony and exhibits JLM 1 through 3 in this proceeding?
I did.
Do you have any corrections to make to those exhibits?
I do not.
If I were to ask you the same questions contained in those exhibits, would the answers be the same today?
They would.
Walmart would ask for the admission of Dr. McGovern's testimony and exhibits JLM 1 through 3.
Thank you, Ms. Caviglia. We'll admit without objection her testimony and exhibits. Thank you.
Thank you. Have you provided a summary of your testimony today?
I have.
Can you please proceed to state your summary?
Good afternoon, Chair Fenn, Commissioner Harvey, and Commissioner Clark. Thank you for allowing me to appear on behalf of Walmart. Walmart recommends the Commission disallow the use of a hypothetical capital structure for rate-making purposes, which departs from actual capital structure, and disallow from rate-based plant that will not be or is not likely to be in service during from rate-base plant that will not be or is not likely to be in service during the test period. And short and sweet.
Thank you, Dr. McGovern. Back to Ms. Caviglia, if there's anything she wants to add before she allows the witness to be crossed.
Dr. McGovern is available for cross-examination.
Okay. Ms. Smith, it looks like you may be doing the cross-examination.
It's uneventful. The company has no questions.
Okay. Anybody else have any questions? All right, we'll see if Dr. Harvey has any.
Well, I have to talk to my fellow economist.
Fellow PhD economist, just to be noted.
We both do have that.
Although she got her degree at a well-known school, Arizona State versus University of Wisconsin. I'd like to suggest that my comments be stricken from the record. All right, go ahead. I apologize. Just a little levity.
All right. With respect to the capital structure, what do you see as the major harm to particularly your client, but to the general public interest in as well, with adopting hypothetical capital structure that increases the equity beyond actual?
Commissioner Harvey, Walmart is a significant customer of Rocky Mountain Power, and increases in rates impact Walmart in a significant way, and they impact our customers. We operate over 59 retail units in the state of Utah, and we have other services that we take from Rocky Mountain Power. I estimated that, more generally, that annually, the impact of that structure was approximately $25 million to ratepayers. And so on that front alone, the impact to customers is significant.
I think that'll conclude my questions. Thanks.
Commissioner Clark.
I have no questions, thank you.
Thank you.
Dr. McGovern, you didn't include this in your summary, but I think I'll just note for the record that Walmart is a very significant customer of Rocky Mountain Power in the state of Utah, operating 59 retail units and 3 distribution centers and a fulfillment center, and employing over 20,000 individuals in the state of Utah.
That is correct.
Okay. I just want to ask you to explain, if you would, a bit your concerns about the proposal on hypothetical capital structure, on what that does to increase rate base and what it does to impact ratepayers and reward shareholders, if you would.
Thank you, Chair Fenn. My understanding is that the company has an actual and projected capital structure, and that's a capital structure where there's a higher proportion of debt than is put forth as their hypothetical capital structure in this rate case. And the argument I surmise around the hypothetical capital structure is in part a show of support and a concern about the ratings for the company. The alternative to that I see, and I have seen in testimony, is that the company, when it is issuing debt, might have to issue that debt at a different rate, and the debt might be more costly. So, a little bit, as an economist, the trade-off in my mind is the commission authorizing a reward or an awarded higher return on equity for certain versus the company potentially needing to pay more for debt. The math eventually might turn out to be the same, although I am not confident that would be true. But to your comment about the incentive or what this does to reward shareholders, there has been discussion about how the company arrived at this particular capital structure. And I would say that the company could have made different decisions and would not be in the situation of having the same debt equity ratio that they have now. And therefore, when potentially short-term planning or potentially short-term actions result in a debt equity structure such as this, and it needs to be reconciled or rectified, asking customers and the commission to rectify the debt equity structure to boost equity synthetically is counterintuitive to me and also concerning. It sets an example both for this company going forward and also other companies that are seeking hypothetical rate structures. I would say in addition, from a theoretical point of view, the company is the one that is closest in all transactions to the decision-making of their investments and their actions. And the customers have almost no say in that. And so a hypothetical rate structure, or excuse me, a hypothetical capital structure, if chosen by a commission, could be awarded, or yes, I guess awarded, to protect customers who don't have a say in the structure of the company, but to protect the company from the company's own capital structure. That seems also counterintuitive to me.
Okay. Thank you, Dr. McGovern. I have no further questions. We'll excuse the witness.
Chair Finn, do you mind, I apologize for doing this to you again, but do you mind if I ask a clarifying question of the witness?
No, not at all.
Thank you. Dr. McGovern, I'm looking at your lengthy table at page 8. By lengthy, I mean you present a extensive list of utilities with their authorized ROEs noted in a bar chart. Just regarding the heading of the chart. So you're seeing what I'm seeing, right? And I want this to be clear for the record. So would you just note what the table truly refers to? And
My apologies.
that's okay.
Thank you, Commissioner. This table reads authorized electric ROEs versus PSE's requested ROE. I will say for certain this is authorized electric ROEs versus Rocky Mountain Power's requested ROE. In that sense, the table is no different. You can see, even in my black and white version, what we have here is all of the companies and their authorized ROEs. And just as a side comment to previous conversations that have been had this morning, these are case-by-case authorized ROEs for the operating companies. Rocky Mountain Power is shown here, along with the other companies, in highlighted or darker band. This table was constructed I was writing testimony in PSE the week before, so the data is the same.
So the data would be the same except for the black bars, I assume. Is
The
that
data
right?
would be the same except for the highlighted portion. So essentially, we have different companies, and this is what we have in the last 2 years for what we consider a cohort or a proxy group.
And how did you select the utilities that are represented? Is this sort of universally all you could find, or was there some selection criteria?
So, Commissioner, as you know, Walmart operates in many states, and so we collect data on all of the companies that we
I see.
engage with, and so, you know, we do this also for gas utilities. We, when necessary and relevant, we separate out by vertically integrated and non-vertically integrated utilities. And so this is all that we can find that are relative to Rocky Mountain Power's request.
Thanks very much.
My pleasure.
And just one follow-up question on that chart. This is.
I don't know if I'll allow that, Chair Finn.
I usually follow your lead, so I'll just shut up right now. But no, just what's the, what would be the date of preparation of this? Are these the current authorized ROEs of those companies? What's the date of the chart, I guess, is what I'm asking.
Yeah, so I prepared this chart in October of 2024. And this includes all of these companies that have been authorized, these ROEs, in the past 2 years. So some of them are, you know, say a year and a half old, but still in effect. Some are 6 months old, still in effect.
So you believe these are authorized ROEs that are still in effect? Some of them may be the date of the last rate case, which could be a couple of years ago. Okay, all right.
Yes.
Yes. Okay, thank you, Dr. McGovern. Appreciate it very much. You may be excused. Safe travels back to Bentonville, Arkansas.
Thank you. I will be going back to Oregon.
Oh.
We haven't quite fully moved to Bentonville yet.
Oh, okay. Well, it's a wonderful place. When you get there, you'll enjoy it.
I appreciate that.
Okay, let's just talk about schedule for just a second, what we want to do next. It could be a good time to take a break, but let's just see who's next. I'll put it in this file here. So, are we going to start then with Mr. Jones, who's going to introduce the division witnesses?
Yes.
And let's take our break right now. What do you think? Is that okay with you? Okay with everybody else? Let's take a 15-minute break.
22.
About 20 minutes to the hour. Ms. Schmidt, did we confirm with the other witnesses? We did find out that, well, just tell me who else you have scheduled after Mr. Coleman is tomorrow, but who do you have scheduled after Mr. Jones for the rest of the day?
We have Mr. Davis, and then we have Mr. Einfeld.
And they're both confirmed.
They are both confirmed. Orton and Smith could go, except that Mr. Saban requested that no additional witnesses today be listed for cross.
Others can go, just, we were trying to do Mr. Coleman in the morning because I have to be gone for.
We'll do Mr. Coleman first thing in the morning, and with respect to other witnesses after Mr. Jones, Mr. Davis, and Mr. Einfeld, my response to that is niet, okay?
Thank you.
That'll be enough witnesses for the day.
Thank you.
Unless it takes 10 minutes, and then we'll reconsider. All right, we'll be in recess until 20 minutes to the hour.
Thank you.
on the record and turn the time to Ms. Schmidt. We'll begin calling Division of Public Utility witnesses now.
Thank you. The division would like to call Mr. Trevor Jones and ask that he be sworn, please.
Okay, thank you, Mr. Jones. Welcome. Mr. Jones, will you raise your right arm to the square? You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. You may be seated. Turn to Ms. Schmidt now.
Thank you. Good afternoon, Mr. Jones.
Good afternoon.
Could you please state and spell your name for the record and make sure your microphone is on?
Trevor Jones, TrevorJones.
By whom are you employed, and what is your position?
Division of Public Utilities. I'm a utility technical consultant.
What is your business address?
160 East, 300 South, Salt Lake City, Utah.
Have you participated in this docket on behalf of the division?
Yes.
Did you prepare and cause to be filed what has been marked as DPU 2.0 direct in both confidential and redacted form? There were regular exhibits that went with the redacted and regular and confidential exhibits that went with the confidential file testimony. Is that correct?
Correct.
And those exhibits were 2.1, 2.2, and 2.3 in work papers. Is that correct?
Yes.
And 2.3 was the confidential exhibit and the work papers were confidential. Is that right?
Yes.
Is it correct that you did not file rebuttal testimony?
Correct.
On December 4th, 2024, did you file rebuttal testimony, in this case, identified as DPU Exhibit 2.0 SR in both confidential form and redacted form, and with an Exhibit 2.1 SR?
Yes.
Do you have any changes or corrections to your file testimonies?
No.
If I asked you the same questions today that are posed in your pre-file testimony, would you provide the same answers?
Yes.
Do you adopt your pre-file testimony as part of your testimony today?
Yes.
Have you had the opportunity to prepare? Oh, now I'd like to move for the admission of DPU 2.0-DIR with its exhibits and DPU 2.0 SR with its exhibit.
Without objection, the direct and rebuttal testimony of Mr. Jones as well as the exhibits are received.
Thank you. Mr. Jones, have you had the opportunity to prepare a summary to share with us?
Yes.
Please proceed.
Good afternoon, Chairman Fenn, Commissioners Clark and Harvey. Thank you for your time and efforts on this case. First, I'll start by stating the names of the division witnesses who provide testimony in this case. In addition to my testimony, the other witnesses testifying for the division are Dave Williams, whom you've already heard from, Casey Coleman, Robert Davis, Jeff Einfeld, Jonathan Lee, Eric Orton, Gary Smith, Shauna Benvenu Springer, Justin Christensen, Paul Hicken, Ryan Daigle, Doug Wheelwright, Tom D'Ambrosio, Dan Kaler, and Karan Pohl. And the last three are from Daymark Energy Advisors. All right, next, I'll summarize my testimony. And although some of the material I reviewed contained confidential information, my summary only contains publicly available information. I recommend an adjustment to the company's net power costs, or NPC. In 2021, the company changed its hedging program. Specifically for power purchases, the change has increased the volume of purchases to a level that is no longer in the public interest. This level of purchases is not likely to benefit Utah proportionately to its proposed share of the costs. My adjustment is made by changing Utah's allocation of the costs of the power hedging program from 44% to 20%. The division's proposed allocation adjustment is a deviation from the 2020 protocol that is warranted due to the division's statutory obligation to act in the public interest. The lack of detailed information and the ability to track these transactions and their performance makes establishing a precise allocation impossible. This allocation adjustment is the only deviation I propose from the 2020 protocol and the order approving its extension. Thank you. This concludes my summary.
Mr. Jones is now available for cross-examination questions and questions for the commission.
Okay, thank you, Mr. Jones. Ms. Smith, do you have questions of this witness?
No questions.
Okay, no cross-examination. Nobody else has any questions, I guess? Okay, let's turn to Commissioner Harvey and see what he has.
I'd like to examine your rationale for saying that there isn't, in your opinion, a way to get a good allocation for those hedging costs or those hedging contracts. Is that, well, anyway, just give me a little bit more on that.
Okay, so they have the cost, the original cost for the hedge that they've made, that transaction they enter into. But then that goes into what I would term a black box of all the available power. So you don't know if they've sold that, or like when they make a sell of power, it's coming from that black box, but they don't really know if it's coming from that hedge that was entered into. And so it's hard to track that exact hedge, if that makes sense.
Okay. In answer to one of my questions, an earlier company witness referred to a diagram, and I'm not going to be able to tell you exactly which one it was, but it had a nice blue band that basically was the amount of hedges that had been contracted for each period, and then above and below it had additional purchases and then additional sales below. Are you familiar with that diagram by any chance?
Yes, I am.
Oh, good. So you'll make up for my lack. I'm curious at drilling down with you as to why you're concerned about being able to track a particular contract versus the net effect of everything that happened. What's the advantage that you would see of being able to do it individually versus looking at the total net of the transactions?
Just, if you want to be more accurate, you'd want to know like individually to be able to sum them all up. You could just make a generalization. You don't have to be that accurate, I guess. But.
Well, I guess what I'm wondering is if I'm thinking of PacifiCorp's generation stack of all their owned and contracted resources, then various types of purchases they might make ending up with these spot purchases. At any given moment, you can know what things are being used, but you don't know which electron is associated with which piece, right?
Right. So in their dispatch, like they're trying to operate according to least cost, and they use the different resources going up, but you have the obligations to these hedges first, like they're a must-take before the rest.
Oh, okay.
So you'd have to take that full blue block before you move into your resource mix. Resource mix?
Okay. And so your position is that there potentially are, if I think of that diagram again, areas of that diagram that could have been dispatched in a lesser cost manner if the hedge hadn't existed.
Correct.
And so by being able to track individual hedges, you could identify those types of situations.
Mm-hmm.
Okay, that makes.
Yes.
All right.
Yeah. You've already gathered from the court reporter you're going to need to answer audibly.
Yes.
It's hard to take what it means on the record. So.
Sorry.
All right, that concludes my questions. Thank you.
Commissioner Clark.
I just have a couple questions about the overall theory that you're applying to your analysis. First, generally, the Pacific Corp system is operated as a six-state system with generating units physically located throughout that system. Is that correct?
Correct.
And the way the costs of those units are allocated is not related to the location of those units. Is that also correct?
Correct.
So help me to understand the difference between that outlook or analytical approach and the one you've taken with respect to the hedging transactions, where I think you're objecting to the fact that the contracts seem to relate to requirements in the West most of the time. And maybe that's an incorrect conclusion on my part, but if you can get the gist of my question, I'd like you to explain the relationship between how you're viewing how the purchases ought to be allocated under the hedging program versus how the costs of the physical assets are allocated.
Okay. Trying to think how to break that down. So the purchase they're making, whether they're east or west, it's to cover the shortness of the load that they have. So it's not just that it's in the west, it's just overall as the company they're this short due to the planning that they've had and their existing resources. And so to cover that shortness, they're buying all of these hedges in advance, and all of those must be used. And what I'm saying is that the volume of all those purchases that they're making, they happen to occur in the West, but due to that volume they're making, it can't meaningfully serve Utah load or benefit Utah proportionately to the needs we have here.
Because they can't benefit the needs we have here because. I'm just looking for your, complete that thought if you wouldn't mind.
Because the company could have made other resource choices, like in the IRP, they could have purchased something else to cover that the shortness at the peak hour. The company had other options, and they've chosen not to use those.
And so the other options would be other purchases in different locations, or what is it about these purchases that are
I'm saying
preferable to the ones they made?
It's more about the resource mix they have. They could have bought solar with batteries to cover that peak, if that makes sense. So they're buying these hedges to cover just that needle hour, that one short hour, but then that covers the entire quarter. So now, and also for that time period of the hedge, like for 16 hours. So even at 8 in the morning, you're still having to use a good amount from all these hedging transactions. And so I'm saying they could have, just to cover that 1 hour, that peak hour, they could have purchased batteries or another resource to cover that shortness.
Thank you.
Mr. Jones, just a couple of questions. I wanted to just make sure I heard this right in your summary. You stated in 2021, Rocky Mountain Power changed their hedging program. I'm trying to understand whether your assertion is that the change in the program, the volumetric program, resulted in an increase in the cost of the hedges, or whether it's the change in market circumstances and the need for more purchase power and just market conditions generally that increased the cost of the hedges.
So the old program, so they changed the program in 2021 to be more of a supply or reliability program. Like, that's what they were worried about, was the supply, because the old program would tell them to to sell some of their hedges when they needed it, so it would make them even more short when they needed it. So they changed it to be based on supply and reliability. And so the reason for one of the reasons for the increase in cost is just the volumes that they've had to increase to cover that shortness. So they're looking at 1 peak hour, and they've been buying more, to cover that. There has been increased costs in the marketplace, but they're also increasing the volume that they're buying.
Okay. Do you think that the pre-2021 program was a better program for them to utilize, or is there a way you haven't even have an opinion on that?
So before, they were selling the hedges when at times where they needed them. So now they're hedging towards supply because they don't want to be a power company without power. Yeah. So they're hedging to 100% so they can cover that complete load. And so to me, it's all about reliability with this new hedge program. And I haven't seen any analysis based on finances. There's no financial analysis that I've seen on this program. It's strictly based on reliability. And I can understand why they're doing it that way.
Well, would you acknowledge that they need to hedge for load, that they can't run short of electricity and
they don't want to be
on a given day, on a peak day?
On a peak day, they don't want to be short load.
Yeah. You indicated in page 10 of your direct testimony that the company is locking on high prices when it could be producing power for much cheaper, at least for some of the hours at issue. If the company is really concerned about the volatility of the markets, why continue to rely on the markets so heavily? Why not generate more? So you're suggesting that they bring on more generating capacity. You're not suggesting that they're not utilizing all of their capacity on those days where you have a high load, and then for the delta between what their capacity is and what they need, they're purchasing, right? They're using all of their capacity on those days. Is that correct?
So whatever they're short, so at that high afternoon load, that requirement, whatever they're short, say it's 1,000, then they would buy 1,000, and that gets used for the entire day.
Yeah.
And so,
and I understand that.
And they're going to have to back down generation at other points throughout the day to accommodate that amount.
I guess what I'm trying to understand, and maybe this is a company witness question, but they're bringing online all of their generating capacity on those peak load days, and then the delta above that is the hedged amount of energy. Is that correct? Or do you know?
I understand what you're asking, but I'm not sure.
Okay. But generating more, if it's not in existing generation facilities, you can't do that in the short run, you have to build plant, and that would take some time, correct?
They have to build the right plant to cover that short load. I mean, just that one peak. Building just any generation wouldn't work. You'd have to build something that can cover that peak.
Okay.
Because if you can lower that peak, then you can lower the amount of hedges for the entire day.
You stated that the company's provided no analysis of this question I'm going to ask you, but do you take the position that purchasing real-time or day-ahead would be, in some cases, less expensive than purchasing high-load hour hedges sometime in advance?
Some days it would be.
Can you
How
expl-
often
can
I
you
don't.
explain?
What?
Can you explain that?
So I've mentioned like 8 in the morning, you're using a good amount from these hedges. And if you go on the real-time market, it would be cheaper at that time to purchase if you needed.
But at 3 o'clock in the afternoon, when you have everybody turning on their air conditioning, if you haven't hedged with a longer-term contract, you could be paying.
It could, yes, it could be more or it could be less. And that's unknown until you get to that day.
Okay. I want to understand your adjustment on the hedging program versus PAC East and PAC West. You've testified that your understanding is that 90% of the hedging program benefits the west side of the company. Is that correct?
90% of it takes place there. I don't know about how much.
I think I
benefits,
misspoke. 90% of it takes place there,
Correct.
because I'm going to get to this issue of benefit.
Yes.
So 10% is used in the east side, which includes Utah.
Correct.
You make an analysis that rather than using the 2020 protocol where Utah would take 44% of the allocation, that it should be allocated 20%.
Correct.
How do you arrive at that if you say that 10% is what is the actual amount that is utilized on the east side?
Yeah. I used that 10% as my base, saying it should, at least 10% should be allocated to Utah. But I gave there is some benefit to being part of the system, and those hedges, they do have benefit, and that's why I increased the amount more than 10.
Okay, I appreciate that. So I guess I'm trying to understand, as I heard the testimony of the company witnesses, that they hedge for the entire 6-state system. They take a holistic approach, and they claim that the hedges benefit the east side as well. And that's, you have a statement in here, is this on line 305 through 308 of your, or 3010, excuse me, of your direct testimony? Let me just read that to you. The company has not provided substantial evidence as to what share of its west side hedges actually displace the need for shifting east side resources, or how much capacity exists to transfer power from west to east in order to serve east side load with west side hedges. It is not just and reasonable to include in rates costs for transactions needed to meet load in another part of the system if they're not truly displacing generation or purchases in the east side of the system. Recall that testimony, you can refer to it if you need to.
Yes.
Help me understand what you're trying to say there, as that differs from the company's position with respect to the holistic approach that they're taking.
So I agree with that holistic approach. And what I'm saying is that the amount, that allocation, that full benefit to, or like that full amount is not being allocated proportionately across the system. The benefits are higher to that west side than Utah.
Okay, and so if I understand what you're saying is, at least it is high enough that there ought to be a variation from the 2020 protocol that Utah is not benefiting to the extent of 44% of those hedges.
Yes.
Is that a decent summary? I don't mean to put
Yes.
words in your mouth.
Yes, that's a fair statement.
Okay. All right, I think I understand your position. I have no further questions. All right.
Pardon me?
Oh.
May I be permitted to just ask a couple of
Oh,
clarifying questions?
absolutely, particularly since the commissioners may have necessitated you asking a question or two.
I don't think that you did, but I have
Well,
some.
all right, thank you then, but go ahead.
However, I have some that I'd like to ask
But go
anyway.
ahead, you can ask some questions.
Thank you. Mr. Jones, could you please explain some of the problems that the division has encountered in trying to understand and evaluate the hedging programs since 2021?
Okay. So some of the problems we've had is when we've asked for a cost-benefit analysis, nothing has been provided. Some of these transactions like we've asked about and we haven't, like if we asked how many, for the sales, they haven't been able to provide those to us.
You said that you've met with the company many times, and I believe that you most likely have met with them many times and had many more discussions with the company. Has that enabled you to understand the hedging program completely yet?
I understand it a lot more, and they've been very good about answering my questions, but I don't think the hedging program is completely understood. I don't think there's been a full analysis on all the costs. Knowing that, like, when they purchase that hedge for the entire day, how much is that really, like that, when it's being used in the morning and they're having to back down other generation, what is the true cost of that hedge? I don't think that's ever been analyzed.
Do you think that the company has been able to show that it can evaluate the company's costs and benefits of its hedging program yet?
Say that again?
Do you think that the company has the ability to evaluate the costs and benefits of its hedging program?
Yes.
To your knowledge, has the company been willing to consider other options or to track or report performance in ways that would enable outside evaluation of the program?
I don't think enough information has been supplied to do that.
Thank you. Those are all my questions. Thank you for the opportunity.
I think, Ms. Schmidt, since we allowed you to ask some questions, we'll ask Ms. Smith if she has any questions she'd like, or Mr. Kumar, one of either of you.
Give me 1 second.
Sure, please, take your time to decide whether there's questions you want to ask.
Mr. Jones, I just have a few questions for you. You stated, I believe in response to certain questions from Ms. Schmidt, that the company has not provided you a cost-benefit analysis regarding the hedging program.
Correct.
Now, isn't it true that in order to understand a full cost-benefit analysis, you have to understand which resources would have been dispatched in these specific hours? Isn't that correct?
Correct.
Isn't it also true that you would have had to understand how the company's ability to purchase power in those hours as well?
Correct.
And so, isn't it also true that the company's purchasing of power impacts the larger market? Let me rephrase the question. Isn't it true that the company's purchase of power impacts the prices and volume of products available at a given market hub?
Yes, depending on like the volume of purchases, the company can affect the prices based on the number of purchases.
So, and as a result of those significant variables that would change as a result of different actions taken by the company, a true counterfactual analysis may not be possible.
To that degree of sophistication, maybe not, but you could come up with an easier estimate of those, or like something less sophisticated.
I have no further questions, Your Honor.
Thank you, Mr. Kumar. I think that will conclude our questioning of you, Mr. Jones, and you'll be excused.
Okay.
Thank you very much. Appreciate it. Okay. Next is Mr. Einfeld, is that correct?
The division will be calling Mr. Robert Davis. He'll be appearing remotely.
Oh, all right. I apologize. I went here to look and thought that I would get it correct, and
Everyone else has left the call.
Mr. Davis apparently will not be appearing remotely. No, I think he's on. Mr. Davis, are you with us?
Yes, I am.
Okay. Do we get to see him, or are we? Deadpool versus Wolverine would be good about right now. We'll give you a second to see if we can pull you up visually, Mr. Davis.
Okay.
Give us just a moment. But we hear you fine.
Okay, good, thank you.
Okay. Touche, you got me there.
Close to the microphone.
I do.
Thank you. Thanks. Nice to have you with us today.
Thank you.
Mr. Grecu is going to. I'm just, before you begin your testimony and your summary, we're going to ask you to speak in as loud of a voice of conversational tone as you can, and speak as close to the microphone so that our court reporter can make sure that she's able to transcribe all of your words. Okay, go ahead.
Thank you, Mr. Chair. You beat me to it. Mr. Davis, could you please state and spell your name for the record?
Yes, Robert Davis, R-O-B-E-R-T. Last name is Davis, D-A-V-I-S.
By whom are you employed and what is your position?
I'm employed with the Division of Public Utility as a utility technical consultant.
And what is your business address?
It is 160 East, 300 South, Salt Lake City, Utah, 84114.
Have you participated in this docket on behalf of the division?
Yes, I have.
And did you review the company's filed application, amended application exhibits, and testimonies in this docket, as well as filings from the other parties?
I did.
Have you also reviewed responses to data requests?
I have.
Did you prepare and cause to be filed your direct testimony filed on October 17, 2024, along with DPU Exhibit 12.1 through 12.7, and your surrebuttal testimony filed on December 4th, 2024 in this docket?
Yes.
Do you have any changes or corrections to those filings?
I do not.
And if I asked you the same questions posed in that testimony today, would you provide the same answers?
Yes.
Do you adopt your pre-filed testimony as part of your testimony today?
I do.
At this point, I move for the admission of Mr. Davis's direct and surrebuttal testimony and associated exhibits.
Okay, without exception or objection, we'll admit Mr. Davis's pre-filed testimony and exhibits.
Thank you. Mr. Davis, have you prepared a summary to share today?
I have.
Please proceed.
Thank you. Good afternoon, Chair Finn and Commissioners Clark and Harvey. Thank you for accommodating me to appear virtually. Rocky Mountain Power uses corporate and leased aircraft in support of its operations. As
Okay.
evidenced in the flight log.
Mr. Davis, hang on just a second. We're having a hard time hearing you. Is there any way you can get the microphone closer to you or speak just a little louder, because our court reporter wasn't able to catch the beginning of your summary?
How is this?
It's a little bit better, but not a lot. Is that the best we can do, probably?
Okay. About now?
No.
Is
If you
better?
would project like you're playing Hamlet and speaking to the back of the concert hall or the auditorium, that would be great.
Okay. I will talk loud.
That's better. Okay, let's begin. Let's have you begin your summary again. Wouldn't that be best, you think? Or would you just
Yeah,
go?
we're just a few sentences in.
Okay, would you begin your summary again, Mr. Davis?
Okay. Good afternoon, Chair Finn and Commissioners Clark and Harvey. Thank you for accommodating me to appear virtually. Rocky Mountain Power uses corporate and leased aircraft in support of its operations, as evident in the flight logs provided in its responses to the division's data request questions. The division is tasked to review regulated utilities expenses for prudency and determine if those expenses are in the public interest. In this case, the division is somewhat at a disadvantage in that it has to rely on Rocky Mountain Power staff understanding of the aircraft use patterns and properly adjust the aircraft expenses between regulated and non-regulated flights. Without documentation that demonstrates the accounting treatment of regulated versus non-regulated aircraft expenses, the division would find it difficult to vet the aircraft use and expenses. Rocky Mountain Power's witness, Ms. Shelley McCoy, provided information in her rebuttal testimony that was not provided in its responses to the division's data request questions. Had Rocky Mountain Power responded to the data request similar to Ms. McCoy's rebuttal, I would not have proposed the adjustments to the aircraft expenses in my direct testimony. While the division still has some reservations regarding the use of the aircraft and accounting procedures used by Rocky Mountain Power to distinguish aircraft expenses between regulated and non-regulated expenses, The division believes RMP reasonably accounted for the corporate and leased aircraft expenses in this general rate case. In conclusion, I am withdrawing my aircraft expense adjustment. I recommend that in future general rate cases, all aircraft expenses, corporate and leased, be identified for regulated and non-regulated purposes and reported appropriately above and below the line with properly formatted supporting documentation with references and intact formulae indicating the adjustments. This concludes my summary. Thank you.
Okay, thank you, Mr. Davis. Mr. Grecu, anything else?
Nothing else. The witness is available for cross-examination and questions.
Okay, is there any cross? Thank you, Ms. Smith. All right, Commissioner Harvey.
I do have.
Okay, great. Commissioner Harvey.
Good afternoon.
Good afternoon.
It sounds like what the division has concluded is that Rocky Mountain Power has been able to account for the categories the flights were in, essentially. Is that correct?
Yes, that's correct.
Do you or the division in general have an opinion on the public interest in having Rocky Mountain Power use a corporate jet versus commercial airlines?
Yeah, I do. I think the use of the King Airs that they use are twin turboprop airplane.
Sorry, could you start that answer?
So, hang on a second, Mr. Davis. It's the word, it was King Air, the use of the King Air, and then go on from there, Mr. Davis.
Yeah, the King Air aircraft is a twin turboprop airplane that it can get into a little higher altitude, shorter strip runways where some of Rocky Mountain Power facilities are located that are also not served with commercial airlines.
And as a follow-up, was there documentation provided that allowed you to say which of the regulated flights, as you put it, were to those types of areas versus areas where a commercial alternative might have been available?
They identified, in the flight logs, they identified where the legs, the flight legs went to, so it wasn't hard to research where those areas were located and airstrips and that kind of thing. So it was possible to do it, yes.
Do you have a feeling for what percentage of the time a commercial flight might have been available?
Probably, I don't know what percentage would be, but probably pretty low percentage of available commercial flights to most of the locations they were flying to.
All right, thank you. That's all my questions.
Commissioner
Thank
Clark.
you.
No questions, thank you.
I don't have any questions either, Mr. Davis. Seeing that, Mr. Grecu, do you have anything to follow up?
I do not.
Okay, Mr. Davis, that was short and sweet. We hope we didn't interrupt I hope you're up there on vacation. Is that correct?
No, I live here, actually.
Oh, okay. Works where you're here, but lives in Montana. What a good life. I don't know how I can work that out. Okay, we'll excuse you, Mr. Davis. Thank you for your testimony. Appreciate it very much.
Thank you.
Okay. All right, now we'll go to Mr., I want to pronounce this right. Is it Einfeld? Correct.
Yes. The division would like to call Mr. Einfeld to the stand and ask that he be sworn.
Mr. Einfeld, welcome. Thank you. Would you raise your right arm to the square? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please be seated. The this also your witness, Mr. Grecu? This is
Mine.
yours, Ms. Schmidt, please.
We're playing ping pong, sorry about
It's
that.
okay, no problem.
Good afternoon, Mr. Einfeld.
Good afternoon.
Could you please state your name and spell it for the record?
Yes, my name is Jeffrey S. Einfeld. First name Jeffrey is Jeffrey. Middle initial is S. Last name is Einfeld, Einfeldt.
Who is your employer and what is your position with that employer?
I'm employed by the Division of Public Utilities in the state of Utah. I'm a technical consultant.
Could you please provide your business address for the record?
I hope so. 160 East, 300 South, Salt Lake City, Utah. 84114, I believe.
Thank you. Have you participated in this docket on behalf of the division?
Yes, I have.
Did your participation include reviewing file testimony, drafting and reviewing data requests, analyzing issues, and participating in discussions online, on the phone, or in person to discuss matters in this docket?
Yes.
Did you prepare and cause to be filed what's been marked as DPU Exhibit Number 10.0 DIR, your pre-filed direct, and your 10.0-R, your pre-filed rebuttal?
Yes.
Do you have any changes or corrections to those?
I also did a surrebuttal 10.0
Thank you.
SR.
Do you have any changes or corrections to your testimony?
No.
If I were to ask you the questions today that are presented in your pre-filed direct rebuttal and surrebuttal testimonies, would your answers be the same?
Yes.
Do you adopt your pre-filed testimonies as your testimony here today?
Yes, I do.
The division would like to move for the admission of Mr. Einfeldt's direct, rebuttal, and surrebuttal testimonies.
Without objection, we'll receive the direct rebuttal and surrebuttal testimony of Mr. Einfeld into evidence.
Have you had an opportunity to prepare a summary to share with us?
I have.
Please proceed.
Good afternoon, Chairman Fenn and Commissioner Clark and Commissioner Harvey. Thank you for the opportunity to present the division's position on two aspects of the general rate case. I address Rocky Mountain Power's request to establish Schedule 92, a new mechanism to accumulate costs related to excess liability insurance, specifically related to increased liability insurance costs for wildfire insurance coverage. I also addressed Rocky Mountain Power's continuation of the pension balancing account, referred to as the PSABA. In this case, Rocky Mountain Power proposes to establish Schedule 92, a new tariff it has entitled Insurance Cost Adjustment, or ICA. Through this proposed new mechanism, Rocky Mountain Power seeks to charge ratepayers directly for these costs, separately from base rates established in a general rate case. This proposed mechanism is a new balancing account for wildfire liability insurance costs. The division recommends the Commission deny the company's request to establish this new Schedule 92. Schedule 92 unreasonably segregates and would recover a set of costs that may increase in the short term while leaving other rate items in base rates, including items that might decrease and provide savings to ratepayers. This proposed single item carve-out from traditional rate making diminishes Rocky Mountain Power's incentive to act efficiently and effectively to control such risks and related costs. and will likely not lead to just and reasonable rates that are in the public interest. Parameters for the proposed ICA remain ill-defined, including the level of support from other stakeholders. The division's concerns that Utah ratepayers will be required to significantly supplement insurance-related costs of ratepayers of other states remains unsatisfied. The Commission should resist continued attempts to expand the reach of expense reimbursement mechanisms outside of normal rate making. With respect to the pension balancing account currently in place, Utah Association of Energy Users witness Kevin C. Higgins recommends terminating the pension balancing account, referred to as the PSABA, that was established in the company's 2020 general rate case. The division recommends the PSABA remain in place. Rocky Mountain Power's pension plan was discontinued several years ago, and the determination of pension assets, liabilities, and costs remains complex and volatile, and is governed by IRS and U.S. Department of Labor laws. Rocky Mountain Power's increased efficiency and management practices relative to its pension plan will have little to no effect on the associated current or future assets, liabilities, and costs. The PSABA is designed to ensure ratepayers pay the prudent pension costs incurred going forward and nothing more. The balancing account is simple in design and does not require significant time to prepare or review annually. For these reasons, the division recommends the PSABA remain in place. This concludes my summary.
Thank you.
Mr. Einfeld, thank you. I'm sorry, I just wanted to thank the witness. Go ahead.
Mr. Einfeld's available for cross-examination and questions from the commission.
No
Ms.
questions.
Smith, no
No
questions.
questions.
Commissioner Harvey.
With respect to the ICA, Schedule 92, you said in your summary that the division was not, well, I'm sorry, I don't remember the exact words, but that there were other stakeholders that the division was not sure they'd participate. Is that correct?
Not exactly. I'm referring to the meetings that the company and the division and other stakeholders have had with regard to the wildfire issues. And so my comment, I believe if I can restate it, parameters for the proposed ICA remain ill-defined, including the level of support from other stakeholders. So that mechanism is not highly defined at this point. Support for such a mechanism by the division and by other rate stakeholders that the division is aware of, that support, the division is just not comfortable that there's significant support for that yet.
So there seem to be what I would describe as structural participation issues the division's concerned about?
Pardon me? I believe that the questions are veering into what were confidential meetings, so I would advise the witness not to discuss things from those meetings, but to rely upon his general knowledge of the concept and concerns.
Okay, I think that's a fair caution and admonition to the witness.
And with that said, structural and conceptual remains ill-defined.
Okay. Does the division also have concerns about the allocation of the expenses that would be the subject of that account?
Would you be so kind as to repeat that?
Sure. I guess I'm getting at is, I'm going to rephrase rather than repeat. You've just talked about some of the initial reasons that the division isn't sold on the idea. I'm wondering if an additional set of reasons is how the actual insurance expenses would be allocated.
The division has concerns with regard to how those are allocated and are proposed to be allocated, and plans on addressing those in phase 3 more thoroughly.
Okay. Then with respect to the pension balancing account, my recollection of Mr. Higgins' testimony was that there hasn't been any activity in that account for some time. Is that your recollection?
I don't recollect him mentioning that. I anticipate there is activity in that account. There was activity in that account this year. The first year, if I recall from memory, the first year that there was a report made, there was a balance established in that account in favor of the company, if I remember, something around $7 million subject to check. And the second year that activity was reported, which was this last year for the year ending 2023, that balance, the activity reduced the balance due to the company by a significant amount. My recollection is that balance now, the cumulative balance is about $2 million. This year, there is an anticipated activity, a report on activity for 2024. The company has indicated in preliminary discussions earlier this year that they anticipate that balance to continue to move towards benefit towards ratepayers. So a reduction again in costs, or a reduction in what costs are included in rates currently. I know the company has included no costs for pensions going for the 2025 test year, which would generally indicate that there's not going to be activity. But that whole area is so complex. Pensions, as the commissioners may recall, is fairly complex. A lot of moving parts that are outside of a company's control who has a pension that they have to comply with. And those same issues that caused increases above what was in rates in prior years could come back and could cause budgets to be set that could then lead to either the company not recovering enough to pay for the prudent costs, or recovering more than what they should, and then ratepayers ending up paying more than what they should. This mechanism is in place to try to assure that ratepayers do pay the full amount of pension costs that are prudent, but no more than the full amount of the pension costs, which could take place when somebody budgets and then, conservatively budgets that amount to be higher than what it is.
So the division's recommendation is simply to leave that in place until it's completely done.
Or it gets to a point where the balances are immaterial enough that it's not worth the effort anymore, which will likely be a number of decades from now.
All right, thank you very much.
Okay.
Commissioner Clark, do you have any questions?
No questions, thank you.
Mr. Einfeld, I don't have any questions either. Thank you so much for being here today and your brief testimony. We'll excuse you now.
Thank you.
Well, this reaches the end of the witnesses that we had prearranged. I have the next witness is Mr. Lee with 0 cross-examination prepared. Would Mr. Lee be ready to testify this afternoon?
Will you give me just a couple of moments to make sure?
Sure, because the other alternative is I can give everybody 15-minute reprieve and we can go home.
Well, Perhaps it would be difficult for me to find Mr. Lee?
No, he's right.
Oh, Mr. Lee is here and willing, so I think that we probably could put him on the stand very, very quickly.
I'd like to do that just
Okay.
to keep this thing rolling along.
Sure.
Okay. Please go ahead and call your witness.
The division would like to call Mr. Jonathan Lee. Could he please be sworn?
Mr. Lee, welcome. Thank you for being there in the back and willing to testify. Probably on pretty short notice. You didn't know this was going to happen today, I don't think.
I've been following.
Okay, you thought we might get to you. Okay, will you raise your right arm? Mr. Lee, do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. Ms. Schmidt, to you.
Good afternoon, Mr. Lee.
Good afternoon.
Could you please state and spell your name for the record?
Yeah, it's Jonathan Lee, JONATHAN LEE.
Sorry, say that again?
LEE.
Okay. By whom are you employed and what is your position?
I'm employed with the division and I'm a utility analyst.
Could you please provide your work address?
It's 160 East, 300 South, Heber Wells Building in Salt Lake City.
Have you participated in this docket on behalf of the division?
Yes, I have.
Has your participation included reviewing file testimony, drafting and reviewing data requests, analyzing issues, and meeting with others online, by telephone, or in person to discuss these matters?
Yes.
Did you prepare and cause to be filed your direct testimony on October 17th of this year, pre-marked as DPU exhibit number 11.0 DIR, and did you cause that to be filed in both confidential and redacted form?
Yes.
And did you prepare and cause to be filed your surrebuttal testimony on December 4th, DPU exhibit number 11.0-SR, with its exhibit number 11.1-SR?
Yes.
Do you have any changes or corrections to your pre-filed testimonies?
Yes, I do.
Could you please walk us through them?
On my surrebuttal testimony on line 119, there was a inadvertent addition of a number 8 in there.
I'm sorry, could you repeat that a little bit more slowly for your attorney?
Okay, in the surrebuttal testimony on line 119, I believe, let me just double check here. On 119, there is a inadvertent letter K at the end of the line, and then on line 120, there's a number 8 at the beginning of the line.
With those corrections, if I asked you the same questions that are present in that pre-filed testimony, would your answers today be the same as in your pre-filed testimony?
Yes.
Do you adopt your pre-filed testimony as corrected as part of your testimony today?
Yes.
I would like to move for the admission of DPU exhibit number 11.0 direct, the pre-filed testimony of Jonathan Lee in confidential and redacted form, and DPU exhibit number 11.0 SR, again in confidential and redacted form, with the surrebuttal exhibit marked 11.1 SR.
Thank you, Ms. Schmidt. Without objection, the testimony and the corrected direct testimony, the surrebuttal and the exhibits will be received into evidence.
Thank you. Mr. Lee, have you had an opportunity to prepare a summary?
Yes.
Could you please share that with us?
Sure. Thank you, Commissioners. My testimony recommends that the Commission limit the amount of property tax expenses approved in this case to be no greater than $154.1 million, as presented in my rebuttal testimony. It is noted and appreciated that the company has recognized a significant overstatement of property taxes in its original filing. The company has now lowered its requested property tax expenses by $17.7 million from its original $179.7 million to $162 million, as noted in the rebuttal testimony filing of company witness Mr. Fuller. The property tax expense number the company submitted during the rebuttal phase of this rate case in its updated master property tax estimation worksheet for the test year 2025 of 160.
Excuse me, Mr. Chair, I think I just want to clarify. I think Mr. Lee may have mentioned numbers that were marked confidential in his testimony.
Okay, how do you propose you want to deal with that? What's that? Yeah, why are they confidential, Mr. Clark, Commissioner Clark asks?
Let me double check. Happen to have a copy of Mr. Fuller's rebuttal, and I can double check
Okay.
to see how they've been marked.
Yeah, I guess the question, wouldn't property taxes be discoverable as a public record?
Well, and I think the concern is, and we're double checking, I'm not sure about the specific numbers, but the reason that some of those, the estimated property taxes for the test year are confidential is because some of the agencies that we engage in our tax practices in front of, oftentimes those property taxes result in significant litigation.
Sure,
and
and settlements.
And as a result, the estimation, when you get down to the extreme specifics of the estimation procedures and the numbers that result from those estimation procedures, the public release of that could harm our ability to prosecute some of those appeals and could provide certain insight into our estimated procedures and harm our ability to get the lowest property tax rate for our customers.
Well, we wouldn't want to jeopardize your negotiations with property tax, with like the state tax commission or other taxing authorities. And so I understand that. I do have my doubts about whether those are, the assessments are confidential, but to the extent, Mr. Lee, you can not use any numbers that were marked confidential in the testimony. If they're confidential, they should have been marked in the testimony as confidential. Ms. Smith says they are.
Yes, they were marked confidential in Mr. Lee's testimony and Mr. Fuller's testimony.
Okay, so to the extent you can avoid giving a specific number that is marked confidential, or we can go into confidential session. Let me ask the question, can you give your summary and your testimony without using specific numbers, or should we go into confidential session, counsel? You have to weigh in on that as well.
The division requests that the numbers be stricken from the record, if that is possible.
Well, sure, you can strike anything from the record. We can do that. We'll do that. And that solves the problem. But that didn't answer, Mr. Lee, didn't answer the question.
I will avoid the numbers, and I'll just say they're proposed numbers, and I'll leave out the actual numeration.
But you can give the basis and the philosophy for your adjustments without giving the actual numbers, correct?
However, I like to know for the commission, earlier on the testimony, other witnesses have mentioned the number that Rocky Mountain or Pacific Core reduced off their property taxes, so it's already out.
You know, we had like the $22 million, for example, a number by which it was reduced. I'm not sure we had the original assessment and the actual dollar amount that it ended up, but we did have the delta. That was discussed, and open testimony, correct?
Yeah, I think that the delta is less concerning than the actual numbers.
I hear you. Okay. All right, so we'll strike any reference in the transcript to the specific confidential dollar amounts of assessment or settlement. And so that would mean if you did talk about a delta, the change, that I don't think you would get an objection as to that. Is that correct?
I believe so.
I think that's correct, especially if we've already discussed it.
Yeah, you already have. So if you want to talk about the difference between assessment and actual, that's appropriate. Just don't use what the assessed value and what the actual settlement agreement was because of the company's concern that that could cause them some difficulty. Commissioner Harvey, though, has a comment.
Just a question. Can he refer to the division's recommendations? Or are those considered confidential as well?
Well, I thought that I just heard they were marked confidential.
Yes, the division's recommendations are marked confidential.
Even though they're not an assessment and they're not a company estimate?
If you pull up his, both his direct and sir rebuttal testimony, those numbers are marked confidential. They're the highlighted portions on the confidential versions that you've received.
May I have a moment?
Out for your.
Pardon me. May I have a moment just to check that?
Yes, we'll give you a moment. We'll just go off the record for a second or two. Everybody relax. You figure that all out, and then we'll go back and figure out how we do this. But there is an option. We can go into confidential session if you'd like. I don't think that's going to be necessary, but let's see if we can get this resolved.
Right.
On the record, yes, Ms. Schmidt.
The division is concerned about the use of the delta because through relatively simple math, someone could work into the company's numbers. So the division would propose not to discuss the delta, and the division would prefer not to have to go into confidential session if Mr. Lee thinks he can present his testimony today, his summary today, without those things.
Okay, I'm a little confused how the delta will lead to that if you don't have one more input, but in any event, it doesn't matter. I don't have a preference. If you've been listening to all this. I'm sure you're a very smart man and can give your testimony without causing any concern about disclosure of confidential information.
Chair Finn, I do need, for the record, I need to know if I need to strike all of those references to the delta.
You don't need to strike a reference to the delta. You need to, because no delta was used, and we're not going to worry about going back to the previous testimony that was a couple of days ago.
Okay.
Commissioner Clark.
So we have Ms. Ramos's dollar recommendation for property tax expense, I think. Is that right? In the record and without it being marked confidential. It's on page 55 of her, let's see what testimony I'm looking at here.
Sir rebuttal?
Sir rebuttal. So can we not have the division's recommendation of the property tax value that the division recommends? That's what I don't understand.
So I think, Commissioner Clark, how I would interpret that is if it's already in the record and wasn't objected to, confidentiality should be waived with respect to that. It's already in the record.
I believe that was Ms. Ramos's recommendation, not the division's.
Right. But I don't understand the distinction between the division's recommendation and Mrs. Ramos's recommendation from the perspective of confidentiality. I can see why the company's adjusted proposal, why they might be sensitive about that being public, but.
Are you looking at line 1136?
I am, yeah. Am I
So-
just way off here?
No, You may not be way off, but I will say that number is a different number than the number that Mr. Lee had stated and is marked as confidential in his testimony.
Right, but is it truly confidential? Is there a reason for it to?
So, so one other comment on that, Mr. Kumar. Yeah, I understand what you're saying about your assessment and settlement and negotiations, but each case is judged on its own merits, and what has happened in the past with respect to a settlement, I'm not sure why that should cause you so much concern.
I don't think it's the past amounts that we're concerned about. I think it's the future amounts, the projected amounts for our test year that we're concerned about.
Okay, but you don't have there's not a resolution of a matter or pending matter yet on this before a taxing authority, is there?
Not to my knowledge. I can say that I did have a few conversations with Mr. Fuller about this, and I'm representing the conversations that I've had with him. And I do know that we do take great care to protect the amounts that we are estimating in property taxes. To the extent that Miss Ramos's testimony identifies a certain number, I think we'd have to go back and double check on that. I do think.
That's fine too.
She did.
All right, we have I think not a meeting in the minds with respect to whether this information is truly confidential or not, and I'm not seeing that we're going to resolve this here, so I'm going to put us into confidential session. Make sure. Okay, we've been discussing for several minutes here Mr. Lee's testimony and whether it would require the disclosure of confidential information. We haven't quite reached a resolution of whether it will or will not, and there's some dispute about that. But just to remove any uncertainty and to protect any information that the company feels is confidential and would perhaps damage them in their pursuit of tax matters, we're going to, pursuant to section 54-2-4-204, consider whether there is good cause warranted to close this public hearing and go into a confidential session, closed session. Go ahead, somebody started to say something.
I deeply apologize for this, and I think we've been going off the division. Division was probably being extra careful in how they mark things confidentially, and we really greatly do appreciate that. But I have been talking to Mr. Fuller, and I've gotten some more details that may help.
I was right in the middle of a brilliant move. Okay, no, seriously, that would love to not go into confidential session, just a hassle.
The total property tax amount is not confidential. So I believe Mr. Lee's summary is not confidential, which I think solves a lot of problems. And I believe it may have been marked, the division may have been extra careful, and we appreciate that and how they marked the testimony. And I think that's what triggered some of our initial response. But it's the state-by-state amounts that are confidential. So
And,
the aggregated amount of total property taxes is not confidential.
I don't recall state-by-state amounts in the testimony.
I do not recall it being discussed at the hearing. There might be some in some testimony exhibits, but I don't believe it's been discussed in the hearing so far.
Okay, Mr. Lee, you do not intend to discuss state-by-state tax amounts, is that correct?
I do not intend to. There's a part in my summary where I get to talk about one state, but I'll just kind of leave out the numbers and we're good.
Okay, the commission will no longer consider closing the meeting. We'd like to thank you for your resolution of that matter. It could have been done much more timely, but we're 10 minutes, no, I'm teasing, just teasing. Okay, so let's go forward. I think the objection at present has been withdrawn, and we will ask Mr. Lee to continue his testimony with a caution to avoid state-specific numbers which the company is concerned not be disclosed as being confidential. Okay.
Chair Finn, just so I understand, the matters that were moved to be stricken and were stricken are no longer stricken, is that correct? The numbers that Mr. Lee mentioned in his summary.
Yes, I think that's a really good point. So unstrike what was stricken. Please, okay, she's got it. All right, continue, Mr. Lee.
Can we pick back up the property tax expense number the company submitted during the rebuttal phase of this rate case? Do you see that?
Please say that again.
Oh, sorry.
Okay.
The property tax expense number the company submitted during the rebuttal phase of this rate case in its updated master property tax estimation worksheet for the tax year 2025. After that is where we left.
Is that a good place for you to start?
Yeah,
Okay.
that works.
Okay, go ahead. You can start with a complete sentence if you were interrupted mid-sentence. Go ahead.
Okay, I'll just repeat that because it's the property tax expense number the company submitted during the rebuttal phase of this rate case in its updated master property tax estimation worksheet for the rest of the year 2025 of $162 million aggregate. It's still an overinflated property tax expense number. My analysis of the company's master property tax estimation worksheet that the company has submitted still has the same fundamental concerns that were mentioned in my direct and rebuttal testimony. For instance, some of the formulas shown near the top row of the spreadsheet do not necessarily lead to the correct number per the formula in the calculated columns. This can be seen in the estimated net property taxes for 2025 for a couple of state listed. In addition, the estimated net property taxes for the year 2024 are plug numbers, and I cannot determine the underlying calculations and whether those estimated taxes are derived accurately or not, and those are listed by the states. The company updated master property tax estimation worksheet now shows an actual January 1, 2024 assessed value total of $15.5 billion and an estimated net property taxes of $148.7 million, which is lower than the actual shown in its original worksheet for January 1, 2023 of $15.8 billion assessed and $154.7 million net estimated property taxes. Note that this represents a decreased assessed value and estimated net taxes to be paid from 2023 to 2024. Nonetheless, the company increased the 2024 assessed value for the 2025 test year by $1.12 billion or 7.2% to $197.3 billion, which brings the company estimated net property taxes for 2025, in this case, to its number of $162 million. Although the company has lowered its assessed value and estimated net property taxes in the spreadsheet by using the lower and more updated January 1, 2024 assessed value, the worksheet still does not address the fact that some of the company property tax appeals will be successful and eventually lead to refunds, which will reduce the actual amount of property taxes that the company will have to pay. However, once the commission sets the rate in this general rate case, any amount less than the property tax amount set by the commission becomes a windfall revenue to the company. Thus, the company will collect and will not have to repay rates based on property taxes that the company did not have to pay. My recommendation for allow property tax expense now is based on the new information provided by the company that 2024's assessed values and the corresponding property tax that the company will have to pay for 2024 will be even lower than 2023's actuals, since its base 2024 assessed value is now lower than 2023's assessed values. Because the company updated its assessed value information for 2024, I now recommend my less conservative property tax number of $154.1 million that was provided in my direct testimony using the 5-year average and a 0.3% year-over-year growth estimate. Though this number is less conservative or otherwise less generous to the company than the $164.1 million that are
Say that number again?
okay. Though the number, which is the 154.1 million, is less conservative or otherwise less generous to the company than the 164.1 million that I originally recommended in my direct testimony based on the 10-year average and a 3.5% year-over-year increase. It is still roughly in line with the company's new estimate for 2025 property taxes, if that number is being adjusted downward by 4.54%, the successful appeal factor used in my analysis. If the commission wishes, it could adopt the division witnesses Mr. D'Ambrosia's method for adjusting property taxes, then apply the 4.54% adjustment for likely appeal results. As such, I recommend that the commission consider the above factors when settling the property tax expense in this general rate case. Accordingly, my recommendation to the commission is to set the allowed property tax expense at no greater than $154.1 million. That concludes my testimony.
Thank you, Mr. Lee. Ms. Schmidt?
Mr. Lee is now available for cross questions and questions from the commissioner.
Ms. Smith, are you handling cross? Do you have any cross?
We have no questions.
Okay. All right, I wouldn't think anybody else does either, so we'll turn to Commissioner Harvey.
And I'll note that Ms. Schmidt said commissioner, not commissioned. She's probably right. Just to summarize the philosophy of your testimony overall, you're interested in ratepayers being charged for what Pacificor ends up paying, not what they're assessed.
Correct.
Okay, that's all I have. Thanks.
Commissioner Clark.
No questions, thank you.
Just one clarifying, I think that this is just a statement you made from your summary. You recommend 154.1 million on a 5-year average. The 5-year average is the actual property tax paid, correct?
Correct. And
Okay.
it's the latest 5 years.
Last 5 years?
Yeah.
Okay. I have no further questions. All right. Anything else? Okay, Mr. Lee, you are excused. Thank you.
Thank you.
All right, we'll stand in recess until.
Chair. I apologize. I was asking to be excused for the remainder of the hearing. I will not have cross for the DPU witnesses.
Is there anybody who has any objection to that? Ms. Caviglia, thank you so much for you being here. We will excuse you from the balance of the hearing. Will you be participating in phase 2 or phase 3?
Phase 2 for sure. I believe Walmart is still deciding on phase 3.
Okay, all right, thank you. You're excused for tomorrow and for the balance of phase 1.
Thank you.
All right, thank you. All right, before I recess. Well, I guess I should have seen if anybody else had anything besides Ms. Caviglia. Anybody else have anything you want to bring up? So let me just note that we will start with Mr. Coleman. Mr. Saban has a commitment. He's conducting the cross, as I understand that. So we'll take Mr. Coleman as the first witness. And then I understand that you have 3 witnesses that can only appear tomorrow. We'll take them next. We've handled 3 witnesses that were scheduled for the 17th. So after those 3 witnesses, we'll take Orton and Smith. And if we, I think, could you have Springer and Christensen on standby? Is it possible they could do the 17th if we get to it?
I have asked all the remaining DPU witnesses to please be ready for tomorrow.
Oh, my heavens. Let's just
I'm an optimist.
crush this out and be done on the 17th. Okay. I don't think that'll happen, by the way, but. All right, we will stand in recess till 9 a.m. tomorrow.
Thank you.